Claudia, you ready? Mm-hmm. Then we'll call us to order. Everybody, please rise and join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Y'all go ahead and sit down. I'm going to do introductions and kind of go through the order of things, and I'll have you stand back up and get sworn in a minute. So for the respondents who are here today, my name is Drew Smith. I'm the Code Enforcement Special Magistrate for the city. My role in these proceedings is to be an independent trier of fact. Each case will proceed in generally the following order. The Code Enforcement Officer will present the city's evidence and testimony. After I've received that, any respondent will have the opportunity to ask questions of the Code Enforcement Officer related to the case. If there are no questions or after that, then the respondent will be given an opportunity to present to me any evidence testimony you'd like me to hear. When I've heard everything, received everything that's been introduced, I will weigh the evidence and enter a verbal order today. That will be followed in the mail by a written order. We're going to take the cases a little bit out of order from the agenda, unless there's an objection. First case will be If Only LLC, since we have counsel here on that one. And from there, we're going to go in the order I think that people came in. So case number 2 will be 2023-963, Pablo D. Fabro. Case number 3, William Martyr Jr. And case number 4 will be Doris Rizzo. And just to confirm, at the moment, we do not have anybody present here for 2023-1334, Cipriano Rene Borrell and Ada Luz Borrell. Anybody present for that case? Okay, then we will keep with that order that I just announced. And you're welcome to stay there. You can come forward if only counsel, or you can stay there until. You don't have to come up right now, but you're welcome to come forward if you'd like to. But she's about to call your case, and then we'll have the Code Enforcement Officer come up. And actually, if I could have everybody's going to introduce testimony today. If you would stand where you are and raise your right hand. Is your client going to testify? If you'll stand and raise your right hand. Anybody else going to offer testimony to me today? No? Okay. Do you all swear from the testimony you give us the truth, the whole truth, and nothing but the truth? Thank you. Help me remember that anybody was born.
Case number 2023-1471, If Only LLC, owner, location of violation, 1525 10th Street, St. Cloud, Florida.
Yes, sir.
Good afternoon, Magistrate. Jack Morrison for the City of St. Cloud. We have the court reporter here and counsel for the respondent here. What I wanted to do is offer a brief opening statement. Officer Bennett, Community Compliance Officer Bennett, present the case. We do have the
Okay.
official here as well. So
I have no problem with that, but if you're going to offer an opening statement, I'm going to extend the same courtesy
Yes,
to your opposing counsel.
Yes, absolutely understood. All the statement is essentially to present is that there is some history between the parties, as is readily apparent by the attendance here today. But this is a code enforcement case being brought, which case was initiated in August of this year, subsequent to the reaffirmation, the ordinance which adopted or readopted the IPMC, previously 2009 version, now 2021, for codification purposes, in an exhaustive attempt to be clear to all parties as to what the issues are, though those issues are readily apparent to all. But it's a narrow issue in terms of the violations that have been cited by the city. Officer Bennett is here to present those, as well as building official, but we would encourage the magistrate to keep the case on track to those issues and not delving into the history of what has gone on, including prior litigation between the parties. That's all I ask. Thank you, sir.
Counsel, would you like to give any kind of introduction?
May I defer until after the city presents its case?
Yes, sir, absolutely. Code Enforcement Officer?
All right. Good afternoon. April Bennett, Community Compliance Officer for the City of St. Cloud. I'm presenting this case for the property located at 1525 10th Street. At this time, I would like to enter into evidence the following items. Copy of the notice of violation sent by certified mail, posted on the property and City Hall. Copy of the statement of violation and notice of hearing sent by certified mail, posted on the property and City Hall. Copy of the PowerPoint presentation, affidavit of postings, evidence of mailings, the code section in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $275.70. And they are here.
Thank you.
On August 1st, I observed.
Before you start, you
I'm
didn't
sorry.
say anything. I assume that respondent has been given a copy of the packet that you handed to me.
Yes.
Okay.
On August 1st, I observed the building at this location to be in disrepair. I sent out a notice of violation by certified mail, posted the property and City Hall, did an affidavit of posting, and 17 photos were taken.
As you go through these photos, can you tell me what you want me to see here?
This is just the front of the building. It's showing my, my posting in this one. This is in the rear of the building. The roof has fallen in on that area. These are just basic pictures of the condition of the building.
Is there anything about the condition of the building that you want me to note as I look at these?
Just the disrepair.
Okay, can you go back 3 photos? Specifically, what is it that you want me to see in this photo?
So on that one, the roof eaves are in disrepair. The picture's kind of dark, but they are just in disrepair and falling. The wood is rotten.
Anything different? Anything, back one? Anything different in that photo than the other one, or is this more of a wide-angle view?
Just a
of what you
wide angle
showed
of
me in the
that
prior
picture.
one? Okay. And here, what am I looking at?
That is just, there's boarded up, I don't know if it's a window or a door. Up there, up top is, again, just damage to the exterior of the building.
That one I can see.
Okay. That one is, that big door there, there's wood rot damage at the bottom of the door. That's what that photo is for. That's another side of the building with the stucco coming off of the roof area up there. Closer picture of that. This is the back side of the building. Again, the wood around the roof line there is rotting. Closer picture of that. That is a picture of the roof area. Again, rotted wood. The roof is deteriorating. It's a boarded up area on the back of the building. Rotted wood. More rotted wood. Another side picture of the building. That's more of the door. And I think, I can't see where we're at. We're on 9.
9-1 looks like.
Okay. I feel like these got out of order, but
So I didn't mean to distract you from your presentation, but I wanted to understand what I was seeing in these photographs, and I think now we're cycling through future, later date photos of the same things that I've seen. Now I've got a grasp of what you're talking about, so you can go back to your presentation now.
okay. That's just a picture of the roof in the back corner. Again, the yellow is, there's holes in the roof to where that is deteriorating. On September 1st, a re-inspection was performed and the violations were not corrected. I sent out a statement of violation and notice of hearing by certified mail, posted the property and City Hall, did an affidavit of posting, and took 16 photos.
Was there any change in condition between inspections?
No, sir.
Go back one. Okay.
On September 8th, a reinspection was performed and the violations were not corrected. 17 additional photos were taken. And I'm sorry, we had already gone through those. Those pictures seem out of order. I'm not sure what's going on with that. It is the city's recommendation that the respondent be found in violation of allowing an unmaintained and unsafe vacant structure dangerous to the life, health, and safety of the public and not corrected by the time specified. The city would recommend that the respondent be given until November 12th, which is 60 calendar days, to bring the property into compliance, or a fine in the amount of $250 a day be assessed until compliance is met. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $275.70 to be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
Talk to me about the dangerous condition. I've seen the photographs, I've seen the condition of the property. I have not heard testimony as to what causes the safety risk.
Okay.
If we could, Your Honor, we'd like to present.
Okay, so you're going to have another witness for me on
Yeah,
this
the
one?
building official can speak to those issues.
Okay.
He's here, he's been sworn, and he can.
Then, for the time being, if you'll stay there for 1 second, Code Enforcement Officer, do you have any questions for the Code Enforcement Officer before I let her?
I do have a few.
Any of you would just state your name for the record before you start. and-
Good afternoon, Nathan Maloon on behalf of If Only LLC.
Okay. And I'll just, you're free to do an opening whenever you want to, but since you're here, if there's anything you want me to think of contextually before you start asking questions, I will still extend you that
I'll
courtesy.
still wait for my opening
Okay.
until after their case in chief, but.
No problem,
I'll still
just
ask
want
some
to,
que-
yep.
Good afternoon. The notice of violation, this is what was sent to If Only LLC, correct?
Correct.
The first two, three, 4 pages where it ends with your signature,
Correct.
The date on that notice of violation, please.
August 1st, 2023.
Okay.
For number 1, where it states unsafe structures, how was If Only LLC put on notice as to what they should fix?
Unless there's an objection, it's the Code Enforcement's question to answer.
Can I see your document,
Yeah.
so you're showing me? Okay. But can you repeat the question?
Yeah, what in here was put on notice as to what If Only LLC should fix to come into compliance?
The violations are listed there for the things that were in violation. They're broken out by the numbers, the code sections that they're in violation of, so they should be detailed on that letter.
Okay, so for number 1, an unsafe structure is one that is found to be dangerous to the life, health, property, or safety to the public or the occupants of the structure by not providing minimum safeguards to protect or warn occupants in the event of fire, or because such structure contains unsafe equipment or is so damaged, decayed, dilapidated, structurally unsafe, of such faulty construction or unstable foundation that partial or complete collapse is possible. How does that state what the violation is and how it should be fixed by If Only LLC?
Can I get both of you to pause for 1 second? Can I get you to pull that microphone towards your mouth?
Yes.
Code Enforcement, can I get you to step this direction, and I'll put you on this microphone so they can get you upstairs?
Is that one on?
No. Is it on?
This one's on.
And that's fine, you just step close to that microphone, and that way they're picking you both up for the recording. Sorry about that.
Okay. Can I turn away from it? Is it going to pick me up?
Face the microphone.
Okay, so the violations, I believe, are listed at the top. There was a section that was listed of what the violations were. And it should have been in bold up at the top of the letter of what we were looking at, but I would have to grab my file and take a look at it.
You're free to do that.
Okay, so at the top where it's states the date that an inspection was performed, underneath says that there's it's listed below the 2021 International Property Maintenance Code sections that were observed and that were in violation. And it also states if there's any necessary permitting to be obtained, that the work or the permits be obtained within 30 days. And then all work being completed must be done by a licensed contractor, and then it lists out the violations that there are.
For number one, on the violation, unsafe structure, how, does this document state how that violation is shown?
I'm just going to have a standing objection because the community officer is code compliance officer, yes, but works in tandem with the city and the building official subject to these issues. And while she does hold, as part of her duty, giving the appropriate notices, some of these questions are asking for an opinion that would become from a more qualified witness, ergo the building official. We would also state that the notice is on its face informative of the action to be taken to a general statement for the respondent, and that any particular repairs and or corrective action should be taken by the respondent needs to be determined by the respondent as the property.
Okay, so,
May I respond briefly?
go ahead.
Ms. Bennett signed the letter and sent the letter, so I think I have the, and she offered it into evidence, so I'm cross-examining her about what's in the letter.
I
And-
understand, but before we get too deep, too far into the weeds on this, I can read the letter the same as everybody else in the room can. And so you asking her, where does it say? I think
Speaks for
you're-
itself.
You're asking her to make, I mean, I was expecting actually a cause for legal conclusion objection, because that's what I would say. Because you're right, it does, it speaks for itself. So if you would like to, I think you've asked the question once, and I think you got the answer that you're going to get if you keep asking it. But perhaps if you rephrase the question to, is there anywhere else in this letter that gives more description than what I see here as to what the violation was or what needed to be done to correct it? I think that's good. I think that's what you're trying to get. Is there more than what we're seeing? Because I think we can all read the letter, what it says here.
Thank you. Is there anything else in this letter that puts If Only LLC on notice as to what their actual violation is?
No.
Beyond what we see in the letter.
Right.
Was that the question?
I have no further questions for this witness.
So your question was only related to number one, or was that related to 1 through
1 through
15? So that I understand the question that was asked and the answer that was given. So the question was, is there anything more descriptive that was sent on August 1 than what I see here in this letter?
No, sir.
And the answer to that is no.
No.
Fair? Is that, and that's the
fair.
question you want to
That's
answer?
correct.
Okay, thank you.
That's more efficient than going through each 15.
I thought it might be, and I thought it might make everybody's life easier. You wanted to call building official?
Well, just on, if I could, on just reiterate for Ms. Bennett, just to clear up on an issue.
Sure.
With regard to.
Have her come up to the podium, or to the microphone, please.
Ms. Bennett, with regard to notice, you've had previous conversations with the respondent about the issues in this building that the city has had concerns with that are contained in that notice, correct?
Correct.
Previously.
There was other notices that went out previously for that, but I haven't had conversation with him
No,
directly. No,
understand.
we've not
I
corresponded.
understand. Okay, thank you. Yeah, we would call the building official at this time just to provide supplemental testimony as to the presentation of Officer Bennett with regard to the violations themselves.
Okay. And we're getting a signal from upstairs. Everybody who's at this podium, chew on that microphone because they're having a hard time picking up.
Okay.
So.
Yep. Just state your name and your title.
Good afternoon. Bob Deathridge, building official for the city of St. Cloud.
Mr. Deathridge, you're familiar with the notice of violation
I am.
and the statements of violation that are in there?
I am.
And can you explain to the special magistrate the concerns that prompted this case to be initiated and contained in the notice?
Basically, the roof collapse that you could see on the south end of the building, and the amount of rotted wood on the roof structure, as well as the failed roof coating over the metal roofing, which is, that's a foam type of insulation on there that just, since the coating on it has been compromised, every time it rains, that foam gets more and more water on it, which holds the moisture against the metal, which causes more and more rot.
Do you have an opinion as to the safety of this building?
The south side of the building where the roof is collapsing, I would consider unsafe because of the roof collapsing and the additional rot on the structural elements of the roof in that area.
Is the interior of that structure, is it open to the elements?
The interior on the southeast corner is open to the elements and has been for quite some time.
Prior to the initiation of this code enforcement case, have you ever had any direct communication with the respondent about those concerns?
I have not.
Anything else from the building official? Cross-examination?
Have you ever been the plans examiner?
Come up.
Oh, sorry.
We need you on these microphones.
Have you ever been the plans examiner for this building?
I have.
Was your license ever suspended while you were the plans examiner for this building?
Can I get you over to this microphone just so they can pick you up and so y'all aren't having to squeeze in on that one?
Object as to relevance.
It goes to the weight of his testimony.
I'll allow it.
Yes.
During the original plans examination, did you ever have any communications with If Only LLC or its principal, Chris Robertson?
I don't recall.
Don't recall. Was this building ever condemned by the city of St. Cloud?
Again, I have no knowledge of that.
Well, I'll just object as to relevance.
And I'll allow the question and I'll answer.
Have you ever had any communications about this building with Phoenix Building Company?
It's possible that when the plan review was done, that comments were returned to the contractor, I believe, who was Phoenix Building at the time. But I don't have any specific knowledge of exactly what they were now.
No, you can stay. You can stay there. You don't have to go back and forth. You're welcome to stay there. No, you're welcome to talk to your lawyer. You just don't have to run up back and forth up the room. You're fine.
What were the dates of your suspension?
I don't recall.
Would it have been October of 2018?
Object as relevant.
Again, I don't recall what the exact dates were.
Did you review any plans for this building while your license was suspended?
I did not.
Yeah, objection is anything previous to this case being initiated. We would object on the relevance.
Okay. And you would just make that a standing objection?
Yes, sir.
Because I'm going to allow the question.
I understand.
But I'll
I know-
allow you to make
I
the standing
understand.
objection.
I understand you, though.
I have a document that I have some documents that I have multiple copies of. I only have one copy of this one.
Okay, show counsel before you show me.
It's an email from Mr. Deathridge to Charlie at Phoenix Building Company. And the attachment is the plan review comments.
2018.
Correct.
So it falls under your standing objection?
It does.
Okay, I will still look at it. Let me see it before you show him, so I know when he's talking about what I, and tell me what I'm seeing, and then I'll let you show the witness.
This is an October.
Go to the microphone.
Oh, sorry.
It's tricky. Only a couple of rules here, but that's one. Be at the microphone.
This is an October 2018 email from Mr. Deathridge, including plan review comments that are attached.
Okay. And this is a copy that the city can keep?
The city can keep this, correct.
Make sure it gets to the clerk before you leave.
I'll hand you the email that's been seen. Have you seen, what is this document?
It looks like email and plan review comments.
Would those plan review comments have been performed by you?
They would not have if my license was suspended. I would have possibly entered the comments from the building official or a licensed plans examiner, but if my license was suspended, I would not have entered comments.
But you would have sent you sent the email that the plans and comments are attached to?
Yes, the same as a permit technician would.
Okay. Were you acting as a permit technician or as the plans examiner?
I was acting as a permit technician at the time.
Was your title a permit technician?
It was not.
Same objection.
Were you paid as a permit technician or were you paid as the plans examiner?
I was paid my regular salary that I was hired at.
Okay. Is a permit technician paid a different salary than your salary as a plans examiner?
I couldn't tell you at the time.
Currently,
Currently, there is a difference in the salary, yes.
higher or lower?
I'm
It
gonna,
would-
s- I'm gonna stop, and I'm gonna sustain the objection at this point, because I can tell you right now, how much he was making at the time he did whatever he did in 2018 is not going to influence my decision on
Okay.
this case.
I'd like to move that email into evidence.
Same standing objection.
And then I have an additional document. Apologize, I'm used to moving.
No, that's okay.
Additional document, it's the permit details from the City of St. Cloud website. It's multiple pages. I actually might have.
Your Honor, this is where I need to object with a bit of background that I tried to allude to at the beginning. There were interactions between the parties years previous to this initial code enforcement case. This is what counsel and respondent are trying to bring into this case today. This is a code enforcement case initiated in August of this year with regard to the violations cited and supported by the testimony of the witnesses and the photographs presented. Prior interactions, prior attempts by the parties to achieve some type of resolution are irrelevant to where we are with regard to this case. I just have a standing objection because we'll draw this into a direction where it has no bearing on this case.
I respect the argument, and let me give some guidance to everybody in the room. And you've heard it from me before. I know I am going to have a liberal policy in allowing information, and I think that's the right thing for code enforcement magistrates to do. I will also ask you to be respectful of everybody in this room's time and understand. I am going to remind you of what I just said on the last one, because counsel for the city's point is well made, that regardless of what anybody's status with a license was in 2018, if the people who are inspecting this building in 2023 are properly licensed and competent to give the testimony that they're giving today, I am going to rely on today. I'm not very worried about 2018. And understand, I saw the pictures of the building, and you could dig yourself a hole very quickly with me if you spend too much time on this side issue.
Understood. I think kind of I'll go into a little bit what my opening will be here.
Give me the context, and it might
to
help.
give you the context, my client received a CRA grant from the city to renovate this building. And while renovating the building, the city came, and the reason why it's in its state now, and evidence will show what it looked like, the city came, canceled the permit, condemned the building, and cut his power, which is why we're in the state we are in now. The city gave him the money to do this, but has handcuffed my client to where they cannot now proceed, which is why the city doesn't want to have these.
So then let me explain to everybody what my powers are, because I'm afraid you are going down a road of asking me things that I do not have authority to do. I do not have the authority of a judge. I cannot resolve the issues beyond this code enforcement case. I can rule on, is there a violation and what has to be done. If the city has contributed to that violation somehow, you need to be in front of a judge, not in front of me, because I'm very limited in my scope of this case.
I understand, and I have to make my record.
I understand.
I have to make my record, and I think that here the city is using itself as both a sword and a shield.
Perhaps. And so let's discuss a faster way of making that record then. What do you have prior to the notice of violation that you would like me to see?
The permit file, the permit details, and what I was about to introduce into
Sure.
evidence.
By all means, Did you show counsel? Now I've lost track of what I,
I have not, I was.
if you would
pulling
show
it up.
counsel, let's get it into evidence.
And I have multiple copies of this.
Your Honor, I'm just going to maintain the same standing objection on going down this path in this code enforcement case with regard to the history of prior interactions between the parties, the city and this respondent. There's been legal activity which is not bearing on this case, which is a code enforcement case initiated in August of this year, based on city code and based on the violations we've presented before the magistrate.
Go ahead.
We are here on the code enforcement case.
I understand, but you've heard me say what my authority is.
Correct.
And I cannot resolve what happened prior to the notice of violation. And as I'm trying to, fit into my own brain where the parties are coming from, and I'll put it to you this way. I think the argument that you want to make to me is that somehow or another the city has contributed to the condition of the property.
Yeah, correct.
So let me tell you what the case would be if it were a landlord and a tenant. And the landlord were in front of me saying, yeah, I see that the property that I rent to my tenant has some issues. My tenant did that. My tenant started the fire that burned down that wall. I'm still going to look at that landlord and say, but you own the property, sir. You are the person that the statutes give me jurisdiction over. Now, I can, if it's brought before me, rule against the tenant, but I don't have to have the tenant here to rule against the landlord. So I don't know that this is a contributory negligence type situation. I want you to be able to make your record, though, and I don't cut you off from that, but I'm not going to spend a lot of time before 2023. So this packet that you handed me, what in here goes to that argument? I don't want to rush you, but I also...
This goes to show that work has been done on the building, and since the building, and currently we do not know whether the city considers the building to be condemned or not, which would be nice to know. And whether this permit is currently active and whether the work can be done under this permit. And I think that this is different than a landlord.
Oh, absolutely. I didn't mean to make it apples to apples, but I was just using it as a broad example.
If the landlord was the prosecuting authority, then I think we're apples to apples. But the landlord is the one here who's the prosecuting authority bringing this code enforcement case.
I would point out that there is no abatement action underway. There has not been an abatement action taken. And candidly, it's my understanding that the city didn't want to incur, or at least in part, didn't want to incur expense in addressing property issues that fall right flatly in the lap of the property owner. And so code enforcement would seem to be the most appropriate and maybe less hostile way to incite what we're trying to incentivize, which is compliance. Get the property into compliance. That's all the city is seeking. And in fact, the recommendation from Officer Bennett suggested or recommended a 60-day time in which to do so. Obviously, that's within the discretion of the magistrate. So clearly the city is seeking compliance. And it's because if it's a safety issue, as has been testified by the building official, it concerns not just the property owner, but the community,
Okay,
which is why we're here.
Let me zero us in, because otherwise we're going to be here until the wee hours, and we've got other respondents. At this point, let's introduce. What do you want? So this would be
The
respondents exhibit number 2.
correct.
I want you to get into the record everything you want to get into the
The
record.
permit details.
But I am going to sustain the objection on the line of questioning and now state that anything prior to the notice of violation that was issued, I am not going to consider as relevant to my ruling. So I will let you make the record with it for appeal, but I will give you that definitive statement that if it occurred prior to the notice of violation in this case being issued, it will not influence my decision. So you can make your record so you have that, but you do not, it is not going to convince me. And my rationale, landlord-tenant, I don't think it was all that clunky, but it's a little bit clunky. But the reality of it is, if you were to sit here and give me video proof of the city lighting a match, burning down your building, I would still say, yes, but it's your building. You're the only person I can order to fix it. If you want to make them pay for burning down your building, you're going to have to be in front of a judge. Understood?
Understood,
Fair?
correct.
I don't mean to, I don't mean to cut you off, but I also know that you can, exactly that. If you convinced me that, if you showed me video of the city burning down the building, I would still say you're the owner, you're the only person I can order to fix it. If you want them to pay for what it costs, you've got to take them to court, because I can't give you that relief.
Okay, understood.
Okay? So we have this as Respondent's Exhibit number 2. Anything you'd like to say about it?
I'll move it into evidence, but no, just asking Mr. Deathridge if this is if he's seen this before and just to authenticate it.
Absolutely, yes, sir. Do you recognize the document?
I do.
What is it?
It's permit details
And
and a drawing for a modular container.
And on page 3 of this document, at the bottom, Building Department Revision 1 approved. Was that submitted on November 7th, 2018?
Yes,
And it was completed on November 14th, 2018?
yes.
Will the city stipulate to the authentication of the document introduced?
Yes, absolutely. The city will stipulate with the understanding that the city objects to anything prior to this code enforcement case as having relevance on this case.
And I'm allowing the evidence to come in.
Yes, sir.
For the record.
Yep.
And I've already stated that I am sustaining the objection as to whether or not it's going to
Yes,
influence
sir.
my decision.
Understood.
And then page 4, there's an electrical sub-commercial fee.
Yes,
Can an electrical inspection, or can an electrical permit be allowed if there has not been an inspection?
this would have been for plan review.
Were you not the plans review at the time?
Actually, Doug Tillery was the plans examiner on this particular project.
Okay. On page 2, it has the reviewer as you, correct? For building department plan review?
Yes, that was April 25th, not November.
And in, the electrical sub-commercial fee was in June of 2018, correct? That's on page 4?
Yes,
Okay, thank you.
that would have been when the permit was picked up, I believe.
No further questions for Mr.
Okay.
Deathridge?
And at this time, you may later, but for this witness, no other documents to introduce?
Correct.
Okay. Any other witnesses from code enforcement? Before y'all walk back, any other witnesses from code enforcement?
No, sir, other than potential rebuttal.
Stay up here.
I think I already gave most of my opening. I tried to be short and sweet. As my first witness, I'll call Chris Robertson. Do you want to go up there just for ease of the microphones? State your name for the record.
Christian Robertson.
What is your relation to If Only LLC?
I am the owner.
Tell me about this building. When did you acquire it?
I applied for the permit on this building in March of 2018. I immediately received from the planning department here 2 altered and forged documents that I had to have Florida Department of Law Enforcement look into, investigate, and they confirmed that they were altered and forged documents. It took 3 months to finally get my permit in June, and so that's what we're looking at, is the June permit that I had active on this property.
If I could, the question was, how long has he owned the property? Did I not hear that?
I'm just trying to get on the record, sir. Thank you.
I understand what you answer the question. How long have you been the owner of the property?
Rules are informal, and I will allow the witness to give the, counsel has heard.
Thank you.
You know, where I stand on the prior to, council, you know where I
Yes,
stand
sir.
on the prior to.
Yes, sir.
I am going to allow them to make the record, so just as briefly as possible, if you can.
Yes, sir.
Understood. I think in the interest of efficiency, maybe a little bit of a narrative may be more efficient than the typical format. Because I know we do have more respondents waiting. I don't want to be
Yes,
here
sir.
till.
And there is background. I worked in economic development here. I worked for the city manager. He terminated me a few months later. About 5 months later, I pulled the permit on this property, or attempted to, and that's when they altered and forged the documents on me. I had filed an ethics complaint against him for improper use of a city vehicle, and he went through 6 months, so he wasn't happy with me. So one by one, he weaponized city departments, and that's what you're seeing here. And that's what you're seeing here today as well. So it does impact this here. They tried to hit, well, let me go back to June. So June, I got my permit. I started working on it, and I notified Doug Tillery, the chief building official at the time, and I've got a post office business, the United States Postal Contract Unit, and I was attempting to move it into this building, and I said, I've got it opened up for Christmas. Can I put a mobile modular on this property and operate for a period of 4 months? And he gave me all the stipulations. He said, yes, I spoke with Andre, who was growth management at the time, said, you can have this. So I spent about $5,000 clearing the property, getting the container there, buying a bunch of stamps, $1,400 on electrical, and then they refused to give me, actually they said it was approved. I got a phone call the next Monday after I spent all this money saying, I'm not going to get it now. I called Melissa Howes at the time, she's in the audience here, and I said, they've already issued me a tax receipt to allow me to operate out of this. And I said, if I operate, am I going to get in trouble? She said, well, you didn't talk to me, but yes, you can go ahead and do it. A week later, Terry Sparkman and Melissa House put onto the property saying that the building department told them to show up. They didn't know why. Doug Tillery, Bob Dethridge, and Joe Dupree, so Bob did interact with me on this, pulled up onto the property with a red tag attempting to shut me down. At that time, Melissa Howes and Terry Sparkman told them, well, what does he need a building permit for? He's got a tax receipt. You've already authorized this. And so at that point, Doug Tillery left the property. I opened up. He told me he would get me the permit. As it turns out, he did submit the permit. I've always had a permit for that container and electrical inspection. He made it part of the original permit. So when they came in 5 months later and said, you don't have they said, your roof is collapsing. He walked in and said, we're cutting your power in my business. We're cutting your power to the whole property. And he said, because your building permit expired 2 months ago, which it didn't. It was good until June, a couple more months. Your building permit expired because you have not had an inspection in 6 months. Well, that's not city code. City code says commence construction or begin construction. But not only that, I did have an electrical inspection within the 6 months. It was in November, as we've just confirmed, when he made the temporary container a part as a building plan revision to the original permit. There was an electrical inspection on that. That's an inspection within the 6 months. So he inappropriately, improperly canceled my building permit, condemned my building, and then cut my power lines. Didn't take the meters out. He said, OUC will be by tomorrow morning and cut your power lines. They went up in a bucket truck. This power was only 8 months old. Went up in a bucket truck and snipped the lines. This was all about putting me out of business. And there's a letter from Doug Tillery at the time stating that's what his intentions are. If you don't remove that container, you've gotten an electrical inspection. If you don't remove this container, we will take further action. And 1 month later, they did.
Mr. Magistrate,
Officer Neal,
I understand.
I'm
and I
just
know-
putting on
and
the
You
record.
made the standing objection.
there's nothing in these narratives that is relevant to the code enforcement case here before you
Understood.
today.
And I need everyone to understand what I can and cannot do. I cannot give relief on these issues.
I'm not asking for
And
relief, sir.
let me ask a question that maybe will zero us in on what, unless somebody makes a really great argument that I have authority that I don't believe I have, can we go please to one of the photographs of the whole structure that gives a good shot of the roof? It's okay. They'll get to it for me upstairs. Keep going. There, stop on that one. No, go to that one. Yep, let's stop on this one. Is anybody in this room going to tell me that this is in compliance with code? Is anybody, no, I want my question answered. Is anybody in this room going to tell me that this is consistent with the code?
We also don't believe that.
No, I want an answer to my question.
Yes, sir, it is.
How is this consistent with the code?
If it's under permit, yes, sir, it is, because that did not collapse. It was taken off while under permit, and they improperly canceled my building permit.
Go back one photo.
And it's shown in the plans.
Go back one photo. Back. Is the condition of that wall consistent with the code?
I pulled the sheathing off of that and consistent with my permit. While I was
When was
under
that permit
permit.
issued?
In 2018.
When was your last inspection?
In 2018
Your
on
permit is
electrical.
expired.
Well, they expired it then, but and
So,
they stopped me from
Tell me
working
how
on it.
this is consistent with the code.
That is not consistent with this code.
Okay, all I can do is say, is this in compliance with code or not? And if I find it's not, I can tell you to fix it.
Yes, sir.
That's my power.
I understand. I'm the one I'm being brought here, and that's why I'm trying to just get everything on the record.
I know, and I don't mean to be
Yes.
short with anybody,
sir.
but
Yep, I get it.
council is now correct.
Yes.
That you are making the record with things that I cannot decide for
Yes.
you.
Yes.
And have no relevance to an appeal on a code enforcement ruling.
That's between you and that judge, but for me,
Certainly.
Yes, I attempted to fix
I-
my building. They've condemned my building. I'm not able to transfer title. I can't sell it. The assistant city, I'm trying to find it. They can't even tell me if my building's condemned. The chief building official's here. Can I ask him on the record? Can he tell us on the record?
he was asked the question.
Is
He
it
said no.
condemned? It's not condemned. So why was my power lines cut?
That, again,
Well, I've got a picture of a red tag. I've got the building, the picture of the red tag.
my role,
Yep.
is it in compliance with code? If not, what needs to be done to correct?
Yes, sir.
That's what I can do.
I paid $550 for a building permit then, and it was still active. I would like a building permit reinstated.
I can't do that.
Okay. And that's, I'm
Can't
just saying
do
what
any of that.
Yes, sir.
I can say, is it in compliance, and what needs to be done to fix it if I find that it's not.
Yes,
That's
sir.
all I can do.
Yep.
So, is the argument here today that I should, that if I considered all the evidence that I know you would like me to see in here, that I would be convinced that this is all the city's fault, therefore I should allow this building to just crumble into the ground?
No, sir.
What is it that y'all want me to do?
I'm not asking you. The code enforcement brought me here. They've already condemned, my building is condemned. The city condemned it. It's never changed that status. They cut my power lines. Why is code enforcement taking action against something the city's already gotten involved in? They've already taken action against me. Why aren't they continuing to demolish and take me to court for that? And then we can
They
fight it
have
there.
the avenue of Chapter 162.
Yes, sir.
Correct.
It exists.
And 162 is,
Not an abatement action. This is not an abatement
Right.
action. And in
And-
fact, respondent filed a lawsuit, which was removed to federal court, which was dismissed.
For
lack of- right, for lack of jurisdiction.
I sustained your
Yes.
objection, and that's. so
We're
I-
just trying to stay on topic. This is a
Understood.
code enforcement case. The relevant actions are the building as of August 1st going forward, the condition, the pictures, which are clear and accurate depictions as readily acknowledged by respondent.
Our
And seeking a
argument-
compliance date.
So here's what I can do at the end of the day. I can find that the property is in compliance with code, or I can find that it's not in compliance with code. Is there an argument to be presented to me today that I should not find this building not in compliance with code?
We have two arguments. The first is that this is not properly before the Code Enforcement Board, and the second argument is that the 2021 IPMC was not properly adopted, and it's not a proper code that can be enforced.
Are there questions of your witness to those 2 points that you would like to ask?
Yes.
Okay.
Chris, have you ever seen 111.4 of the IPMC?
Objection, questions vague. Which IPMC?
I might have read it online.
Which version?
The 2021 IPMC?
I may have seen it.
I'd like to, I have a copy. I only have one copy. It is the code that we're trying to enforce here. Oh, I misspoke. I do have extra copies of that.
Keep this one.
No objection.
No. 2021 IPMC, no objection.
Okay. What number did you ask? What was the code, Nathan?
Can I see the original document that I gave you? 111.4.
One 11.4 notice.
Is a violation of this code, kind of tell me about what you, about this provision of the IPMC.
Well, let me explain how they just adopted this IPMC a month and a half ago. They, after 14 years of using IPMC and after 3 or 4 years of using the 2021, 3 years, they finally filled in the blanks as to what agency is the appropriate agency to use this, and it's the building department. It's not code enforcement. So they filled that in, and then the IPMC also states that the head of the agency, this is under, so the creation of the agency, section 103 is the code compliance agency. So the building department is hereby created, and the official in charge thereof shall be known as the code official. So he's the one, Robert Dethridge, the chief building official, is the one to enforce this code. The function of the agency shall be the implementation, administration, enforcement of the provisions of this code. This was all adopted a month and a half ago. The duties and powers of the code official is hereby authorized and directed to enforce. You want me to read this through? I mean, you've
No,
got
I
the
can read it
language.
for myself.
Yes,
If
sir.
you refer
Yeah.
me to the sections you want me to
Yeah,
pay attention
yeah,
to.
that's the one. Yes, sir. Section 105, duties and powers of the code official. And then 105.5, notice and orders. The code official, Robert Dethridge, shall issue all necessary notices or orders to ensure compliance with this code. I have not received a notice or an order from Robert Dethridge.
Do you dispute that Chapter 162 also provides other code enforcement notice procedures?
It does, but the city code says that this supersedes all others in conflict.
No,
Is it in conflict, though?
I don't believe it's in conflict.
If
I
they
don't believe
say
it says
separate
what he
things,
says
then
it
yes,
says.
they're in conflict.
I don't believe it says that. I think that's a tortured reading.
Section 107, means of appeal.
Also,
It says it says the violations, I don't need to read those. Let's go back to the 111.4.
I'd
Form.
like an answer to
Notice.
that question.
Yes, sir,
though.
I'm sorry.
Why does the authority of Chapter 162 not apply in this case?
Well, it's not 162, it's any city ordinance that authorizes.
Yeah, but code enforcement
in
is
accordance with 162.
statutory.
That is statutory, but
My
it's,
authority derives from the statute.
but it says that a municipality may authorize a code enforcement to
Do
enforce
you
these
contend the
codes.
city has not authorized code enforcement to enforce code enforcement matters?
Per ordinance and per city code, but when they passed this under conflict, signed by Dan Manzares and the city and the city manager and the mayor, it says conflicts. This ordinance supersedes all others
Somebody
if it's in
point me to that
conflict.
language.
I don't know what language they're referring to.
Let them make their own argument. I'll let you rebut if you have any.
While he's finding that, you want me to read the?
No, I want to wait because this is an important point to me.
When it was adopted, June 22nd, 2023.
That's the first reading. You're talking about the one that was adopted in July? Okay. 2023-33, adopted in July? Yes?
Correct.
Are you referring, to one are you referring?
Should be.
Your Honor, may I put on the record as well? Okay, you want to wait?
I want to wait. Unless it answers this question.
No, it's related to it, but I'll.
So
wait.
let me, now that I hear the conversation between counsel, the section you're looking at, it's a form section that I will see in almost any ordinance that I see that says this ordinance supersedes prior ordinances. Does it say that the IPMC will supersede city code or state law?
It does not say that, but It does not say that explicitly.
Does it say it implicitly?
It does, because this
What
supersedes.
does it say?
This action supersedes all codes and ordinances of the city or parts of in conflict with this ordinance to the extent of the conflict. So to the extent that there's a conflict between the two, the one that was recently adopted that they're trying to enforce here is the one that supersedes and is the one that we should follow.
And if Chapter 162, Florida statute says, notice of violation in a code enforcement matter shall contain these things, does that supersede Chapter 162?
Potentially, but this,
Yes or no?
No, because when the city adopted this, they were saying that they want to use this method for the IPMC. They want to use the method that's listed in the IPMC for violations of the IPMC.
Now I understand the argument. Rebuttal, counsel.
The code enforcement procedures and enforcement procedures are statutory through Chapter 162. The enforcement of the codes that are contained in the IPMC have been adopted and readopted. The 2009 version had been adopted by previous city code and was simply readopted to adopt the 2021 IPMC, but that does not disqualify the community compliance officer from providing the notice of violation and carrying out the duties of a compliance officer and enforcing the IPMC.
Give me 1 minute here.
May I add a few things now, sir?
I'm writing. Give me a minute, and then yes, but give me 1 minute to. Okay, so I'm going to go ahead, and I will still let you say what you'd like
Yes,
to
sir.
say, but I'm going to rule on this one issue. Again, because there's nothing more that anybody's going to say to change my mind if you've made your best arguments to this point. I do not find that the conflict section of an ordinance, and it was not shown to me, but I can envision it. I've drafted many, and so I have a sense now of what we're talking about. I do not find that that conflict section changes the notice provision in the case that's before me. And part of it is what you've heard me say is I actually don't think there's a conflict between the two. They are alternatives. They are, you can always proceed under Chapter 162. And if you were to make the best argument that I think you could, which is that yes, indeed, and I think it's the argument that you're trying to make, is because the city has adopted the code enforcement process that's outlined by Chapter 162, the city can then change that. I don't think so. If the city adopted an ordinance that said, well, code enforcement notices are only going to include the name of the violator and how much time they have to cure, and leave out the most important part, which is part of your argument today, what's wrong, and you were to bring that to me and say, well, Your Honor, the city would bring it to me and say, Your Honor, we've changed the notice procedure. I would look at the city and say, you can't change the statutory notice. And so I do not think you can supersede what Chapter 162 requires, but also allows. And so unless you're going to argue to me, and you might still, we might just not have gotten there, that the notice fails under Chapter 162, I'm not going to find that the IPMC trumps Chapter 162 notice. So I give you that
Yes,
on
sir.
the record,
Yeah,
so that on appeal, that's one of the things you can say, look, Drew was wrong when he said this. So I'm
Yes,
giving
sir.
you a definitive statement on that, but you don't have to keep trying to convince me because you're not.
May I ask a question on that?
I don't have to answer, but yeah.
No, I'm just, so there's Chapter 162, but did the city enact an ordinance authorizing their code enforcement officers to utilize 162?
I don't think they have to.
Okay. There is an ordinance, I have read it, but, okay, that's,
It-
and that is the
it's
ordinance that we're
immaterial
saying
to
this
me
supersedes
because
that.
Chapter
Yes.
162 exists, and I don't think you have to have an ordinance that says we're going to use Chapter 162.
Okay, that's fair. Can I ask Jack a question? I know he may not have to answer.
He didn't have to answer.
He works for the law firm that obviously represents the city. Did the city council properly adopt the 2021 IPMC?
The question is addressed to you, Mr. Robertson, is.
Okay,
Do
I'll
those
strike that.
pictures, do those pictures fairly and accurately depict the building on the dates
We'll
that they
get
were
there.
taken?
So the answer to your question is no,
Yeah.
he's not going to answer that question.
Okay, the
And it's just fine because
2021
he's not a witness.
IPMC was not properly advertised. The The 2021 IPMC, a month and a half ago, the second reading, they had the full context of the code. The first reading, they did not. They were in violation of you got that, Nathan?
I do. Parsons versus City of Jacksonville, and the citation for that is 295 Southern 3rd, 892, and this is a 2020 case, requires that on both readings that the text be fully adopted. And the reasoning of the first DCA in this is that Section 166.041 Florida statutes imposes identical full text requirements on revision or amendment of municipal ordinances. And it states, no ordinance shall be revised or amended by reference to its title only. Ordinances to revise or amend shall set out in full the revised or amended act or section or subsection or paragraph of a section or subsection. And further, the reasoning of the court, I think, is instructive here. It states, it would be difficult, if not impossible, to interpret an amendment to a law or an ordinance without having the entire text in context. The only way to ensure clear, accurate, understandable, and uniform notice of proposed changes to a law or an ordinance is to put them in writing before enacting or adopting them, in full text, in context, complete, as if for immediate enforcement. Without all of that, an amendment is just an idea. Ideas are not enforceable, which is why an amendment that fails to comply with these requirements is void.
Before you respond, let me ask some questions. So I am failing to understand at this point, I just need more explanation. What is the procedural flaw of the first reading?
It did not contain the full text of the what
It
was
didn't have all
enacted.
the code.
Of what? Full text of what? I need to know the full text of what? What is the argument?
Of the 2021 IPMC.
I don't think it had to. The code, it has to have the text of the code that's being changed. Did the first reading have the incorporation language of the 2021 IPMC?
So again, what the case and what the
I
statute
understand
states.
I understand the case. I'm familiar with the case. But what we're talking about is an incorporation by reference. And so the language that exists in the City of St. Cloud Code of Ordinances is the city, something to the effect of the city has adopted 2021 IPMC. That is the code language that case would be relevant to, not the total language of what has been incorporated by reference.
It's our position that in order to be proper, it must be on both readings. Otherwise, it's just an idea.
And you've made the record, and I've given you a definitive statement that you can take me up on appeal, but that is my finding on that argument.
I have a few more questions. The notice of violation that you received that the code enforcement officer discussed, did that tell you what to do to come into compliance specifically with each violation?
No, sir.
Objection.
What's the objection?
The objection is that the notice, it calls for a legal conclusion, and the notice is plain on its face as to what has been directed of the respondent in which to take remedial actions to come into compliance.
I'm overruling that objection because I think it is fair to allow the respondent to testify as to his understanding of what he received in the notice.
How did you know what to do to come into compliance by September 1st?
I did not. Until I saw these pictures, there were a lot of things I didn't know that they were pointing out.
When did you see these pictures?
Today, just now as you saw these.
Do you visit your property?
No, sir.
Why not?
Well, I work on the west side of Kissimmee.
When you
I don't
received the notice of violation, why didn't you go take a look for yourself?
I knew that my building was condemned, and I knew the reasons why they condemned it 4 years ago.
No, I want to answer my question. When you got the notice of violation, why did you not go to your property and say, why the heck did I get this notice of violation?
I don't know. They didn't tell me why. I just saw. I got
How
the
many months ago
well,
were you
this
here
started.
scouting another case?
Well, I'll go back in March. I got a notice of violation on the same thing.
Did you go to your property then?
Yes, sir.
Did you look at it?
Yeah, but I
Was it in this condition when you saw it?
not in the pictures that they showed. I did not know those were issues.
Why is this not an issue?
Why is that right there not an issue?
Yes.
It was taken off. It did not collapse as stated by the chief building official. It was removed. The fire chief, the husband of the city manager, witnessed me taking the stucco off.
What
That
happens
did
when a
not
building
fall
is
off.
exposed to the elements?
Are you asking me a real question?
Yes.
I assume weather gets inside of it.
What happens then? Is this okay?
It's not okay. It's
Why
not
is it in this condition?
It's not okay for the city to do this
Is
to
it
me.
not obvious what needs to be done?
Yes, and I'd like to get a permit, but they will not give me a permit. It's condemned. They canceled my permit. I paid $550 for it. If they will give me a permit and connect my power, I'll work on it.
So did I just hear you testify? Yes, it's obvious what needs to be done.
It is obvious that my building should always be in compliance with the code of the city of St. Cloud.
Is it?
Yes, it should always be in compliance with the city code.
Is it currently in compliance?
It is the interpretation of, I believe you, that it is not.
I haven't ruled yet. I'm asking you. Do you believe it's in
I believe
compliance
it
with
needs to
code?
be, I need to work on it, but I need a permit. And I had a permit.
I understand all that,
Yep.
but you've heard me
Yes,
say
sir.
I can't fix
If
those issues.
I understand. If I get a permit,
I see
would-
a building that's in distress.
Yes, sir.
And I hear a property owner telling me, well, I didn't know what to do, but I can look at a picture on a screen and see what needs to be done.
Well, I never said I didn't know what to do.
He did.
I will,
Your counsel
but
that's the argument
until
he just
today,
presented to me.
there was many of those pictures I did not know needed to be corrected.
And that's why I asked you, did you go to the building and look at it for yourself when you got the notice?
I've seen what I could see, the stucco in the roof, yes.
And you saw then that, did you really need them to tell you what needed to be done in more
Yes.
detail than they already gave you?
Yes, sir. The other things, yes.
What more detail did, let's go through that, because I think you might get
Good.
some traction with me on some of those, but let's go through those. I'll
Yeah.
let you off the hook for a minute. I don't mean
Okay.
to put you on the hot seat, but
That's okay.
you understand what I'm looking at here.
You understand what I've had to go through for 4 years.
I hear it, but I can't fix
Yes.
that, and I can't say who I think is right on that.
Yes. And I'm not
I
asking
can
for you to
just
rule on
deal
that.
with what's in front
Yeah,
of me. I know.
I'm obviously going through this. I was requested to be here. I'm here. I understand.
And you
I
have
need to
every
take
right.
it to another avenue. I don't believe the 2000 IPMC code ever existed. I don't believe I know the 2015 never existed, and that's what they used to put me in this position. They've never included the language to the code until a month and a half ago. The language to the IPMC has never been available to the public in the city code, never advertised until a month and a half ago. That's the problem that we have. It's not just me. You've got 13 years of this.
I hear you.
Okay.
And you've
But I do
heard me
understand.
say this before. When a building's in distress,
Yes.
let's all just agree to get it fixed.
I sat down with the city manager and the assistant city manager back in June, before they took this action, because they hit me in March. April Bennett hit me in March, in including language that never even belonged in the code and altered the language, which is criminal. Dan removed it. They resent it. So then he hit me with the 2009 because he confirmed with, you met Mr. Barrett. He came up here one other time. Mr. Barrett said he spoke with Dan, and Dan said the 2021 is not the code of the city. Regardless of what Jack says.
And I've heard, you don't have
Yes,
to
sir.
remind
And I'm
me
not
of
going to
all
go back into that.
And
But- And Dan hit me with the 2009.
I
Okay.
hear you, but we're here now.
Yes, sir.
We're here on 2021. You have the opportunity to make the arguments about 2021 IPMC that you want to make, but I just want you to also understand what I see and what ultimately has to happen. And me, honestly, some of my frustration is with my own inability to fix the broader issues. I can't. It would be improper of me to try to. But something needs to be happened because
Yes, sir.
my job is to make sure that buildings like this don't just crumble into the ground and certainly don't fall on top of somebody's head. So what I'd like to do, and I will still give you some time if there's other things you'd like to cover, but I want to go through the 1 through 15 and see, I want you to make the argument maybe for each, and if you need to ask your witness questions, by all means, but abbreviated. I'm smart. I can pick up on quite a bit. You don't have to nail it down beyond with what you want to make the record. But if there's any of these that you think are not within context of the ability to view the building, to go on your own property, take a look at the building, if I look at this with the property owner's eye of my own property, if there's a valid argument that this section should not be found because this was too vague and ambiguous, I might be inclined to go along with that. But it's not, well, if I was a stranger to the property and didn't know what it looked like, this wouldn't tell me anything. This has got to be the context of the owner who has every right to go onto his own property and say, if I look at what they said versus what I see, yeah, I see what they're telling me to do. So I'm going to allow you to make those arguments, but which of these fail?
Your Honor, can I show you the pictures of what it looked like before I did the work on it? I exposed it to the elements under permit.
But it's in the
And-
condition it's in now.
Yes, yes, and I want to fix it.
No,
There's
I-
nothing more than me
I
wanting to fix
don't
it.
find the photos prior to the condition that it's in now to be relevant, because I
Yes, sir.
can't fix that issue.
Yes, sir.
Can we mark the photos that he wanted to offer?
Yes, you may, and if we're gonna mark them, I'll take a look at them, and we will allow them into the record for the purpose of the record, but I am not going to.
Same objection.
They are not going to influence my decision. And these photographs were taken when?
That was prior to me, prior to the electrical, prior to
Give me a
me
year.
taking that roof off, I would say 2018,
Okay.
Objections to relevance?
or just prior to the construction.
Objections to relevance, completely.
I think that, I think,
Respondents Exhibit 3, I think.
correct.
And I want
I-
to submit this as well.
Okay.
This was while it was under permit, the container was delivered.
Give me a year.
This was 2018. That was taken off. I built the handicap. That's all per my plans. And as you can see, we work back there. They cut the power. I know you
Speak on the microphone, Mr. Robertson, and object as to relevance. It's 2018 pictures.
And the objection sustained, but I'm allowing it to come into the record. It
Yes,
will
sir.
not influence my decision.
Yes, sir.
An important part of being able to renovate your building are finances. And so when the chief building official and Mr. Dethridge, when he said that he never had any interaction, he was there that morning when they canceled my permit, condemned my building, and cut my power. He walked in along with Joe DePriest. So that was not truthful. The other thing is, they cut the power lines to a separate address. So those are the 3 meters that you see in that picture right there. None of that power went into that building. None of it. One went to the back building, which is a separate address per 911 addressing, and they cut the power. I had a tenant in that one. And so part of being able to fix it are finances. So when I asked the chief building official, I said, "You're cutting my power. How do you expect me to fix my building?" He said, "I don't care what you do with that." It was all about forcing me to remove that container. Had nothing to do with my building. They knew the condition of my building. They knew this was all under contract to fix this, under permit. Had nothing to do with it. It was about to put me out of business because obviously I had the city manager under investigation for his actions, and there were other things. So the former city manager weaponized many departments. At that time, code enforcement wasn't one of them.
Objection, Your Honor. I'm have to-
And
to
again,
object.
I know.
so now we're moving right into that maybe less clumsy analogy that I use, that if you showed me a video of the city lighting a match and burning the building
Yes.
down, I would still be in the position of I can only give the property owner an order to do something.
Yes, sir. And I'm not looking for you to force the city into anything. I'm not.
Okay. We were going to go through the items and which ones of these that you wanted to present to me did not give the owner enough information, again, with an owner's eye of his own property.
For number one, unsafe structure, is this an unsafe structure? That's a question.
I don't believe it to be so.
Do you know, based off of the violation here, what made it an unsafe structure, or what did you do to fix it?
No, sir.
So we're pretty much in a trial by ambush this afternoon for this portion.
Object, Your Honor.
If every property that's under renovation or under construction is deemed an unsafe structure, then everything would be condemned. And we have a lot of homes going up. This is not unsafe. This is just a portion of the roof that I took off to replace the stringers as per the permitted plans.
Same question with number two, sufficient stability. Does this tell you what to do with sufficient stability?
No, sir.
Is it stable?
I believe it to be stable. Yes, sir.
Has it been in that position for years?
Yes, sir. Those are the same stringers that were attached to it. I show them on the plans. And the plans called out to remove that portion of the roof and attach new stringers to enlarge those stringers.
Is the roof, are there holes in the roof, large holes in the roof?
Other than that piece right there of a
Are
piece
there
taken
areas
off.
where wind could get under the roof, to your knowledge?
That's a separate building. So this is that's really, I'm sorry, I know.
Are there areas where wind could get under the roof?
I don't believe wind goes in there. No, sir. I mean, you could say that. I'm not a,
When you say you don't believe wind goes in there, what do you mean? If
Well-
we had a hurricane,
yes, sir.
would a hurricane force wind get under the roof and potentially lift the roof?
I don't believe in that portion, no, because I took out the damaged part.
Have we had a hurricane since this building has been in this condition?
Yes, sir. Yeah, we had a large one back in September.
Does this document that you were provided tell you what to do to make this a sufficiently stable structure?
No, sir, because I don't believe it to be unstable.
For number three, dangerous dilapidation. From looking at the document you were provided by code enforcement and looking at your building with an owner's eye, does this tell you what to do to fix the dangerous dilapidation?
It does not. Again, I don't believe it is dangerous or dilapidated. These were stringers that needed to be, and issues that needed to be addressed. I took off that portion of the roof to address those issues under permit with the city's full knowledge of what needed to be addressed. But no, I do not believe this is an unsafe condition. And this is a very small portion of this entire 6,000 square foot building.
Is this building likely to partially or to completely collapse?
No, sir. This building has stood since 1920.
Number 4, vacant structure unsecured. Based on what was provided to you from the city and looking at it with an owner's eye, how do you know what to fix for vacant structure unsecured?
I don't believe it's unsecured. I believe every door is secured, every window is secured. So I don't believe it's unsecured.
Do children play in the building?
No, sir. Nobody goes in that building.
So the building's not a,
Is it fenced?
It is not fenced, no, sir.
What stops a child from getting into the building?
The doors are locked or boarded up.
What stops a child from climbing the wall in the area where the roof is exposed, or there is no roof?
They would need a ladder or something to stand
And
on
if the
and
child
jump
brought
in.
something to stand on?
If a child or anybody,
A teenager?
yeah. If they
Homeless
do,
person?
anybody could, people leave their windows open all the time, and I don't think they're in violation either. My whole thing is that it's not unstable, it's not unsafe.
But is it unsecured?
It is not unsecured.
But somebody stranger to the property could access the property through the roof.
If they were to trespass onto the property, and if they were to take means of entering the property illegally, by all means, and they can do that with anybody's property.
But I'd have to break a window, I'd have to break in another property.
And you'd have to have some very long legs to scale this wall.
Okay, I'm sorry,
Yes,
Counsel,
sir.
you proceed.
5, responsibility property 301.2. Does this wording in number 5 and looking at your building with an owner's eye tell you what to do to come into compliance with this violation?
No, sir.
Number 6, vacant structures and land. Does this, from looking at the notice you were provided by the city and looking at your property with an owner's eye, tell you what to do to come into compliance?
Well, this has not been vacant or just land for 100 years, 100 plus years. So no.
Exterior structure. From number 7, looking at what is provided to you by the city with an owner's eye, do you know what to do to fix it based on this?
No, sir, nothing. There's nothing in that.
What section are you referring to, counsel?
Number 7 of the certified letter that was sent, notice of violation, return receipt.
I don't have a copy of that.
I
with
believe
me.
it was your first exhibit that you
To
presented.
the witness, looking at the photograph that we're all looking at, that's on the screen behind me and on the screen in front of me, is this a photograph of a property that's structurally sound and sanitary?
I believe this structure is structurally sound.
And sanitary?
What is your definition of
Is it
sanitary?
exposed to the elements? Is there mold?
I don't see mold.
Is it exposed to the elements? Is water coming into the building?
Is water able to access that back shed area of the building? Yes, sir.
You can proceed. I'm just I want to make sure that I'm understanding what the witness is saying. That's why I'm asking these follow-ups, but you can
Right.
proceed, counsel.
Yeah, I think when part of my, I'll kind of explain my reasoning on going through these is that.
No, I
there's-
want to go through, I
Correct.
wanted to go through them also.
There's
yeah.
no, if you had a rooster in residential zone property, you're not allowed to have a rooster. It tells you, remove your rooster. It doesn't tell you how to specifically come into compliance. So I think there's some due process issues with not knowing what to do and not knowing what the actual violations are.
In
It's
this
kind of-
portion, this portion is not classified by the property appraiser as air-conditioned space. The wood, the plywood along the back, it was a back porch area back many years before I had it, and they put up plywood. So this was always exposed to the elements before they put that plywood up. It was a back garage area. This was a mechanic shop.
I think we're on 8.
8, exterior structure, unsafe conditions. Is there anything from the notice you were provided and looking at your building with an owner's eye that shows you how to fix this violation?
No, sir.
Number 9, unsafe conditions, structures, components limit. Is there anything from number 9 here that you were provided by the city or looking at your building with an owner's eye that tells you how to fix your property?
No, sir.
Number 10, unsafe conditions, structural deterioration. Is there anything in this notice that you were provided or looking at your building with an owner's eye that tells you how to fix and come into compliance?
No, sir. And I believe as the city attorney acknowledged that the code enforcement officers are not, they don't even have this kind of knowledge to determine whether something's unsafe or deteriorated. He put that in the hands of the chief building official.
Community compliance officers are deputies of the building official in the building department in the city. They have authority to make determinations within their duties.
Yes, sir.
Let's let them get through their witness questions.
I'm just going
and
off your
I'll
own
allow
word,
the parties
Jack.
to make whatever arguments they want to at close.
I'm only referencing your words. I'm sorry.
Yeah,
Does this,
we'll have more.
from what
Thank
was
you.
provided, are there structural members that have evidence of deterioration or that are not capable of safely supporting all the nominal loads and load effects?
No, sir.
Does that tell you how to fix it?
No, sir.
Number 11, exterior structure roofing. From what's included here and looking at your property with an owner's eye, does that tell you how to fix it?
No.
Protective treatment exterior, from looking at this and what you're provided with the city and looking at your...
Can I ask you to pause? Because I want to make sure that I understand what it is you want me to hear. Is it your position that the city is required to give code enforcement respondents a roadmap A, B, C, D through Z? You have to do all of these things in order to fix this, or is it the city's responsibility to tell the respondent, this is the violation, this is the condition of the property that's causing the violation, and you, owner, you have a right to fix it, or you have the duty to fix it, I should say. But because I'm thinking of demolition cases, or actually not demolition cases, but unsafe structure cases where perhaps the respondent would like to rehab the building, and perhaps the better thing is to demolish it. That's always the respondent's ability. And even when I sit here and I hear those cases, I'm loath, and although I will sometimes do it, look at a respondent and say, I can look at, I'm not saying this in this case, I'm not referring to this photograph, but if I'm looking at a photograph of another building, I can look at your house, ma'am, or your rental property, ma'am, and see that it's going to be cheaper for you to tear it down. I will not order you to tear it down. You have a right to rehab it if you want to. You get to decide how you want to cure the violation. Our job, my job, is to tell you that there is a violation and that you must fix it. Are you telling me that they have to give a roadmap to exactly what has to be done to fix it?
No, I'm saying there has to be some sort of notice as to what the actual violation is. I can't just accuse somebody of theft and say, you violated this Florida statute, you violated the RICO statute. I have to be put on notice as to what I actually did.
Agree wholeheartedly.
Did I just send a text message?
Agree wholeheartedly, but
And that's and my contention with this is that
where does 14, looking at this photograph, somebody please explain to me how 14 doesn't put you on notice of the problem.
I haven't gotten to 14 yet. I think 14 is clear. It says what it says, but it doesn't take into consideration that the building was under construction.
How about 13?
Again, the building was under construction because the city asked for the stucco to be
I
removed. The
understand
city
that,
knew the
but
stucco.
it is, and it's no longer under an active permit, and I can't decide that argument on who's right, who's wrong, on the reason why it's got an expired permit, but it's not under an active permit. And I'm looking at a photograph where I can see a gaping hole in the roof and mold and mildew on the walls and significant building maintenance issues. And I don't think there's a dispute that there's significant building maintenance issues. And some of these, and I do want to keep going through them, but some of these are clear. I don't think it needs a lot of interpretation to look at the code, look at the picture and say, yeah, I see the violation.
I was informed when I tried to appeal this to the proper venue, to the Construction Board of Appeals, and I appealed it within the time, the 20 days per the IPMC, because it was the building chief who did it. I appealed it on day 19. I had asked for that documentation. They never gave me a form. They didn't follow the code because they didn't have the code. I had to ask Deb Clark, who was the clerk at the time, worked for the code or for the boards, And she included the chief building official in the emails, and he said he was going to sit me before you twice, that he was pushing me to code enforcement. I said, that's not the venue. I'm supposed to go to the Construction Board of Appeals, and they never gave me a hearing. And then they lied. Hold on, sir. They lied and said, I failed to appeal it to the Construction Board of Appeals in 15 days, but there's the conflict. The IPMC, if you read, sir, in 15, it said 20 days. The condemnation letter they gave me said 20 days. I appealed it to the proper venue, and they refused to have my hearing. We shouldn't be here today. I was renovating my building. I tried to appeal it at the right time. I did everything I could. And I do want to fix this wholeheartedly. I don't want any problems, which is why I sat down with the city manager, and I went through all of this. And they wouldn't give me answers. They will not tell me whether my building's condemned or not, because they know if it's condemned, why haven't they taken action on this for 4 years? If it's not condemned, why did they cut my power? Why did they take any action at all?
Okay.
They've boxed me in. I want a permit.
But here we are in front of me, and I have the authority that I have, and I have to make the decisions that I have to make.
Yes, sir.
You're right, Council, we were on 11. And so I'll re-ask my question that I asked about 14 that was specific to roofs, but 11, exterior structure, which also talks about roofing components that have defects that may admit rain. Am I not looking at a building? Is it not obvious from what I'm looking at that this is a roof that's going to admit rain?
Is this a roof that would emit rain? That was a question for you.
If rain were to fall out of the sky, where would it land?
Is this, I mean, that's, I think.
Any construction job, if you are renovating or before you put the roof on, of course moisture
We've
is going to
established
get
that
in.
there was an expired
That's-
permit, so this is not an active job site. So
What date did my permit expire?
I don't know, but you told me the last inspection was in 2018, and the permit expires 6 months after the last inspection, at the
Yes, sir.
latest. So
Yeah.
we are talking about an expired permit.
Yeah, and had I not attempted to fix my project diligently, I would not be in this
You
position.
keep making the arguments that I
Right.
can't
Yes, sir, I know.
solve.
I know. And I just wanted-
I'm trying to move us forward so
Yep.
that we can get through this case, so I can get to the other cases. I'm trying to do it with as much deference as I can, but,
I understood.
and at this point, to be a little bit helpful, the back and forth isn't making the record better for you either.
I understand. Let me ask one, and this is all, where attorneys always get into trouble. One last question. Is there anything in this document that charges you with what you've done wrong other than just restating the provision of the code?
It is stating code that is just cookie cutter code in the language.
No different than
that
just saying you committed theft but not telling you what you stole,
Correct.
not telling you when you stole it,
Correct.
not telling you who you stole it from.
That is correct.
So let me ask a question. So is it respondents, and I'm not meaning this as a straw man, I'm really trying to understand. Is it respondents' position that in order to be valid, that this code, that these notices or these sections should have included specifics? If it's a provision about a wall, that it should have said the north wall on the, given an identification of which wall you were talking about?
Correct. And one, in order to be able to properly give us notice and an opportunity to be heard here, to know what we're actually discussing and what we're violating. And number two, this provided a 30 days to come into compliance, to know what to do to come into compliance, to provide that proper notice.
Was a phone call ever made to the code enforcement officer after receiving this notice to say, hey, would you mind coming and walking the property with me so that I can understand what exactly you're talking about? I'm not saying, and I don't want the argument is whether or not that resolves any issue you may claim. I'm just curious, was that phone call made?
In March, when this started, yes, sir, I emailed
Was the site walked with code enforcement?
No, sir, it wasn't walked, but I reached out to get the form so I could properly appeal it. And I emailed 3 times because she included language, said that I had the authority to appeal it. Until Dan said that doesn't even exist. So where did she get that language from, and why did she change it from 20 days to 30 days? It's all funny business, and this is all just trying to rack up fines on me. They're using your code enforcement chambers here to weaponize against me, just like they've used every department. When they condemn my building, they cancel the permit, and this is what they're trying to do now.
Your Honor, let me please. This is a code enforcement case relevant from August 1st forward. This narrative, this record being
I
built
understand. I'm
is
gonna cut
for
you-
something
I
completely
hear you.
extrinsic to the code enforcement case.
Let's move it along. I hear it.
I would love to.
I've told everybody multiple times now what I can and can't do. And we keep on getting back into the area of what I can't do. So let's finish up what I can do. What else would you like me to hear, Council? I think we've gone, I think your last question kind of summarized us through the end of 15 there. What else was it that you'd like me to hear?
May I have a moment?
Go ahead, yes, sir. Sir, come up, you go have a sidebar over there. Sir, if you'll come up to the podium and tell me what you need me to hear.
I got the next case coming, I'm sorry.
Yeah, come on up.
My case is next, and I got about 15 minutes to go right back to my employment, so I can let my guys go for the rest of the day. It's literally on Eastern Avenue in St. Cloud. I can be there and back in less than 15, 20 minutes.
Oh, yeah, go ahead.
Okay.
Yeah, if we'll just move on from scene and we'll wait for you to come
Yeah, I
back,
don't
so we'll
wanna be
still be here.
disrespectful to say I
No,
wasn't
no, I
here.
appreciate it. You go. Thank you.
I apologize. I know we've taken, I
Okay,
appreciate,
it's
I
your
appreciate
right.
the time.
You know, we're here for a reason, so you don't have to apologize for that. It's my job to move us along, that's why I'm trying, but you don't have to apologize.
One thing I would like to put on the record is due to the extensive condemnation of this building and thousands of dollars of attorney fees, it has created a financial hardship on completing this project. So if you were to rule that I had to a certain number of, set number of days, I would need time to get the finances in order to complete it.
How much time do you need to get finances in order?
Would I get a building permit for 6 months? Oh, well, I know you can't give me the permit, but would you give me 6 months to complete this and fix these issues?
And get a building permit, get an active building permit when?
I would get it within 30 days.
We'll get
Well,
there.
I'm sorry, I would apply, but last time it took 3 months. As long as they're not altering documents on me and they're just process it properly.
Okay.
I have
That's good
plans.
information to me. I appreciate
Yes, sir.
you letting me know. So we'll get there, and I may have some more questions when we get there, but we're a little bit ahead of ourselves.
Yes, sir.
But I appreciate you letting me know that, because that helps my thought process. Counsel?
1 minute.
Yeah, sure.
City wants finding a non-compliance. He's got to apply for his permits. He'll apply in 30 days and complete it in 6 months. Is that what you're saying? Is that what you're saying? What the city wants is a finding that you're in non-compliance on these code sections, okay?
Okay.
Then he wants you to pull the necessary permits. Within 30 days is acceptable if you'll do that to meet compliance, and then finish the work related to the necessary work to finish out those permits within 6 months, yeah.
Of issuance of the permit.
Of issuance of
6
the permit.
months of issuance of the permit.
Yeah.
Yeah, not 6 months when I apply,
No, no, no,
because
I didn't say that.
they eat up 3 months of that.
April. We're talking about coming to an agreement, finding non-compliant, 30 days to apply for the necessary
okay?
permits. and then
Time-wise,
6
I mean,
months
you're
for the
okay?
Oh, yeah, I'm
permit
fine.
issuance to
I'm
do
just pulling up calendar, because I'm sure we'll be.
Which, if there's a problem with the permits, it's going to expand. So I need to know, I need to put a parameter. Or do we just want to have, just get it all complied with? The permit shouldn't be hard to pull. Nobody's sitting back denying permits, they're going to apply for the permits, right?
Yeah,
So
text
30 days to apply for the permits, and what's the reason after those permits are taken?
It's good you're available to do
Yeah,
that.
okay, so there you go. So finding a non-compliance, 30 days to apply for all necessary
I'll
permits.
say it again, we
Once
know
permits
we're
are
gonna
issued,
have
6
cases
months
like
from the
this
issuance
one.
of the
We
permit
need
to
to
complete all
let 'em off
necessary
one
work. Yeah?
special.
And waiving administrative fees
No,
today.
no, I'm not doing that.
It's like
No, we're not doing
the
that.
sign.
We're not waiving,
permit
we're not,
check that
we're not,
one. That's when I
Chris,
said
we're not
it.
waiving
I
anything.
don't
We're not
care.
waiving anything.
But for
We're not waiving anything.
people, like people with kids like you, I worry about you. It makes
I'm
no
fine,
difference
but
to me,
yeah, I'll
but
let them know.
it would be
good?
helpful for anybody who
We're
needs
good.
to.
Okay, so what's our agreement?
What you just said, and I'll pay the permit fee and the administrative fee.
Okay, so I can announce this to them?
Yes.
Did you work it all out?
Jack, there's one other thing. I need my power lines back up. The city created that order?
That's, I don't know anything about it. The power, he wants the power lines, or what the power lines about.
You were there. You disconnected my power? You were there.
Doug did that.
No, you were there.
I was there.
Thank you. Did he say he wasn't there before? Do you see what I mean?
He needs the necessary permit.
Your Honor, that power was 8 months old. They inspected it. It's brand new power. In the pictures, you can see it used to have 1 meter.
Your client, your lawyer's telling you something. Listen to your lawyer. No, I'm just telling you, listen to your lawyer. I'm giving you good advice. No, what they're talking is not on, it needs to not be on the record.
Yes,
Because no power goes inside that
contractor's
building.
gonna have to take care of the power, they will have to do a permit for the power.
No, it's a sidebar.
But you need to get a permit, Chris. You need to get a permit. So in order for you to get the power, you need to get a licensed electrician.
Alex, I
to
know the
apply for a
process.
permit. Okay, then why
If you
you
know the
asking
purpose,
this?
then
No, but I was asking the city to reconnect it because they
You
disconnected.
can't.
we're gonna leave, this is up to you. If you want to take the initiative and do this, then we'll agree to it. Okay. My understanding, Your Honor, is that the parties have reached an agreement, which is, correct me if I'm wrong, is that the magistrate will make a finding of noncompliance on the code section cited here today and ask that all code sections that have been cited be found in noncompliance. Respondent is going to take the remedial action necessary to bring the property in compliance, meaning he will get the necessary permits. He will apply for the necessary permits within 30 days of your order, your written order. And once permits are issued, he will have 6 months from the issuance of those permit or permits to complete the necessary work. Additionally, respondent will pay the cost incurred by the city for presenting today's case and will have to pay any related permit fees that go with the permits. Yeah? Okay. Yeah? Does that accurately depict the
You know
agreement?
what's on there is that
You've
there's
got
an
the
order
recording
to
of it, all right?
oversee to not give any power on the property. Will the city
Maybe also
remove that
we
order
wouldn't
so
have
I can
Kimberly
have
back there, 'cause
actual
I'm-
permit? And have, because I've tried in the past.
I don't
and they won't
know
let me.
I don't know anything about that. I
I
can,
know.
I certainly, the city wants compliance. I can assure you, the city would like this property to be brought into compliance. So the city will make every effort to work with the respondent so that these dates that have been announced on the record can be achieved. But in the event that.
Well, that issue is one that was moving forward in my mind as I was thinking of how this works as we move forward, if something doesn't line up. So let me try to talk it through and see if I make sure I'm understanding number one, and number two, see if I can zero in on that one part that I think is remaining unresolved.
Yes.
So we have 30 days for my written order. The respondent will apply for permits to cure the issues that have been cited in the notice of violation. The respondent will pay the costs and permitting fees, the costs incurred in the prosecution and permitting fees for any permits that are required. That's what I have from what you've told me. They will also complete work within 6 months of permit issuance.
Yes,
And
sir.
if I can get everybody to pause there, let me write that down because that's one thing I hadn't written yet. And so our potential gap is what happens if there's a dispute between the city and the respondent on the issuance of permits. And frankly, as with what is been described to me so far, the city is the one who's going to suffer in that, because if that's all I ordered, if it takes 10 years to issue those permits, he's going to have 10 years and 6 months.
Well, okay. We should have in the order that the permits need to be applied for within 30 days of your written order, yes.
I'll tell you what, let me throw this out there, because there's a gap here, because that's where the stipulation ends.
What?
Yeah, because there's a dispute that's not really at issue here. So here's what I'm thinking. You guys are offering a stipulated settlement agreement to resolve the issues, or not a settlement agreement, a stipulated order to resolve the issues, and I appreciate that. And I'd like to further that. So I want both of your inputs, but my thinking is let's do this. Let's go with what you've stipulated to so far, that 30 days to have application in. I'm trusting it will be a good faith application. I'm trusting the city will process it with good faith. And so I'm sure this gap that we've identified will not even occur. And 6 months from the time that permit is issued, work will be done. It's going to go that way. We're all going to be happy. I'm sure of it. If it does not, though, if the permit has not been issued within 3 months, then this case will return to me and I will enter my order, which will then be appealable. If the parties were unable, if the permit is not issued within 3 months, then the stipulated order, wiped clean, you come back here, I will keep under advisement the arguments that have been made, and I will enter my ruling on the arguments that have been made, and then you will have that to take up on appeal.
It works for us.
Okay, but I guess it does, I'd like to know what that, I mean, to
It leaves us
understand.
where if I said, I don't care I don't think you've completely stipulated to a resolution, therefore I'm just going to rule today,
Yes,
I would rule, and if I ruled in the city's favor, they could take that up on appeal.
correct, of course.
And so what I'm saying is in 3 months, we get there if the permit can't be, if there's a permit issue
whatever
that
reason
drags this
is
out.
not issued.
So that we can have conclusion.
Okay, yes, that's agreeable. I would,
4 months, the clerk is saying, we don't have a meeting in December. 3 months puts us into December, we don't have a December
okay.
meeting, so
that's-
4
okay,
months.
We'll stipulate to that. In the event that the permits are in good faith applied for and issued, and the compliance is not achieved within the 6 months of the issuance of the permit or permits, the city would like some type of consequence to attach, even if it's a $100 a day fine.
That's easy to deal with.
But as I say, and that was, I'll defer to your discretion on the amount, but with the 6 months from issuance of permit complete, that's time where if there are logistical problems that the respondent encounters that needs to come back before the magistrate for additional time, that are good faith reasons, we can report that to move the compliance
Absolutely,
date ahead.
absolutely.
Which is part of why we'd like some type of sunset 6 month and then an attached
Oh,
file.
no, I'm not, no. So here's, let me lay it out there again. So the notes that I have are 30 days from the date that I signed my order, they will have permit application in, good faith permit application in. Within 6 months from the date that that permit is issued, they will have completed that work. I have not forgotten that 6 months. It's the gap between application and issuance
Yes.
that I'm worried about,
I understand.
that could give an open-ended, this never gets resolved, and
Yes.
that's all. So if we get to 4 months now out
January.
from today
It's
into January,
Okay.
then I want this put back on the agenda, because at that point, the parties will not have been able to bring to culmination the stipulated order, and then I will enter an order on my own, and either party, whichever party doesn't like the way I rule, will be able to appeal that order. That way it gives finality both to the city, I mean, from the process, taking care of the building, and to the parties here before me. It gives some end date for how long this could drag out. And absolutely, if they're working, if I enter an order and say in 6 months from the permit issuance, they have to be completed, and respondent comes to the city and says, hey, we just found a big problem that's going to delay our project. I mean, respondent probably, if city comes for me and says, hey, they need more time, yeah, as
Correct.
long as it's not disputed, I have no problem
And-
issuing an amended
and
order to give them more
because that door should swing
time.
both ways, the city would like, assuming that things are moving along, at that 6 months from issuance, if there's not compliance, and there hasn't been.
And that's the easy one, because under statute, I can do $250 a day. And under statute, I can do $250 per day for each violation that I find exists.
Yes,
And
sir.
I might not find all of these exist if it's left
Understand.
in my hands.
I understand.
I might not find that any of these exist if it's left in my hands. So that's why, so if we get to that point of end of the road, then, and I'm the one entering the order, it is back fully in my hands, and your stipulated order is wiped clean. So understand, I don't want to tip my hand one way or the other. I could rule against either of you.
No, I understand. But part of the stipulation
But
is. that
if I enter an order, oh, I see, so.
The stipulation, Your Honor, is that.
It's 6 months, I follow you. Now I've zeroed in on your
Are
issue.
non-compliance. That's the starter. That's a non-starter if we
Right,
can agree
but,
with that.
right, if we get to but it only comes back to me if there's an issue with the permit issuance.
Correct, I
So if we
understand.
get the permit issuance, that starts the clock on 6 months, and if there's not been an extension given by the city and presented to me for an amendment of that order, and if there's not some really good reason brought forward to tell me why should I not impose fines, then yes. What I will do with this case is like I do every once in a while I'll do the post-finding imposition. So if we get to 6 months to the day or 7 months, whenever the timing triggers, and you come back before me with a request to impose fines, then that fine that I could impose is $250 per day for each violation. And now it is all 15 because y'all are stipulating that all 15. I'm not saying I might just do $250 flat per day, but I have the right to do $250 times 15 per day.
You understand?
Understood.
You understood?
Understand?
Okay, yeah.
So are we all on the same page?
Yes, sir.
So then then the order I will be entering to, as soon as I do the written order from today is exactly what the parties have stipulated to, which is 30 days to apply from the date of issuance, 6 months to complete. And if that is not complied with, then we'll be into an imposition of fines hearing. If, though, that one little gap in timing occurs where the application is made, respondent has done everything they've needed to do, but 4 months have passed before issuance of a permit, then it's coming back to me and I am going to rule. The stipulated order will be wiped clean and I will rule and give the parties some finality to go which way they will.
Okay, understood.
The stipulated order will, but.
This, only
Compliance.
if they've done everything they could up to that point, only if they've applied for a permit, but the permit has not been issued and 4 months have run. That's when it comes back to me. Otherwise, I go along with the stipulated order. Did you get all that? What a day to have brought her.
You chose a great day to bring her.
Anything else from the parties?
No, I appreciate the city's time and your honor's time.
And I want to say I appreciate respondent. I appreciate everybody's professionalism here. Council, you did a wonderful job. I appreciate you, Jack, as always. I gave you a lot of face palms, but thank you.
Thank you.
Case number 2023-1254.
No, that was the one that just left. He wasn't
He'll
there.
be back.
It was Pablo.
He's coming back.
No, 1254 is 3. Oh, but so, okay. So then we're still on.
So Pablo? Okay.
Yeah.
Case number 2023-963, Pablo D. Fabro, owner, location of violation, 2912 Ivy Stable Lane, St. Cloud, Florida.
Ready? Good afternoon, Pam Neals, Community Compliance Officer. I am presenting this case for the property located at 2912 Ivy Stable Lane. At this time, I would like to enter into evidence the following items: copy of the email sent to the owner, copy of the courtesy notice sent to the owner, copy of the notice of violation sent to the owner, copy of the notice violation sent by certified mail to the owner, copy of the statement of violation notice of hearing sent by certified mail to the owner, copy of the statement of violation and notice of hearing with the new date sent by certified mail to the owner, copy of the PowerPoint presentation, copy of the affidavit of posting, evidence of mailings, copy of the deed to the property, copy of the code section in violation, copy of the cost incurred if the special magistrate finds a respondent in violation in the amount of $216.70. The respondent is here, and I did provide him a copy. On May 30th, 2023, I noticed the business tax receipt license and the certificate of use license are both delinquent as of September 30th of 2022 for the business PDF Express LLC at this location. On May 30th, Catherine, with Code Enforcement Administrative Assistant, sent the owner an email on directions on how to renew the licenses. On June 12th, Catherine called the owner and left him a voice message, and a courtesy notice was sent to the owner. On June 28th, I checked and both licenses were still delinquent. On June 28th, a notice violation was sent to the owner. On July 13th, I checked and both licenses were still delinquent. On July 13th, a notice violation was sent by certified mail to the owner. On July 31st, I checked and both licenses were still delinquent. On August 1st, a statement of violation notice of hearing was sent by certified mail to the owner. On August 11th, I checked, and the business tax receipt license was renewed, but the certificate of use license was still delinquent, and I had not received the certified card back. So on August 22nd, a statement of violation, notice of hearing with the new date was sent to the owner and posted on the property on City Hall. An affidavit of posting was completed, and I took one photo. On August 31st and September 11th and September 13th, I checked, and the certificate of use license was still delinquent. It is the city's recommendation that the respondent be found in violation of allowing a business to be operating without proper licenses at this location and to have the certificate of use license renewed by September 28th, 2023, or pay a fine of $100 a day until compliance is met. The city would like to also recover the costs incurred in bringing this case before the special magistrate in the amount of $216.70 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
Is this a home occupation?
Yes.
I don't have any more questions for you. Respondent? Respondent? Come on up. Do you have any questions for the code enforcement officer before I excuse her from the podium?
Well, the question that I have.
Your name, please. For the,
Pablo Favre, the owner.
okay, do you have a question for the code enforcement officer? You don't have to. I'm just, if you do, now's your opportunity to ask her. I'm not asking for your testimony yet. We'll get to that in a
Right.
second. But if you have any questions for her, you have the right to ask them.
No, I'd just like to know where or how do I get current? Because,
You have to go downstairs to the building department, planning and zoning,
right,
and apply just like you did for your business. You renewed your business tax receipt license.
right.
You just need to renew your certificate of use license.
Okay, so that was the issue, because when I went downstairs and made that payment, I thought that that would cover everything, because I asked them, am I current, this is everything? And they told me, yeah, they assured me that. So that's why the other thing wasn't paid, because I wasn't aware of that.
Yeah,
So-
no, you have to have both.
That's
When-
the thing.
When was the BTR brought into compliance?
Let's see. I checked it on August 11th, and the business tax receipt license had been renewed.
But it was not renewed within the time set in your notice of violation, was it?
No.
Okay.
But I still resent the,
Understand.
notice.
Okay. No, I was just, you answered my question. Okay. Did you have anything you wanted to present to me? And before you do, if you do, I'm going to, I swear to God. If you'll raise your right hand, do you swear from the testimony you give to me today is the truth, whole truth, and nothing but the truth?
Yes, I do.
Thank you.
So the only thing that I wanted to point out is that I'm a truck driver, and my business is not conducted on the address. That's my home address.
Is your home address the address that's listed as
Yes.
you
Yeah.
need to have
Yeah.
the certificate of
Yeah.
use?
So that's the only reason why I haven't been able, to keep up with the paperwork, because I spend amounts of time on the road. So when I finally came out to the last letter, I guess, that I needed, to pay for the permit, that's when I came on August 10. I made a payment, thinking that that would cover everything,
And
not knowing that I had the second thing that just stuck with her.
And so that's the part that interested me. I overheard the conversation going on. That was the part that was interesting to me, and I'll explain why. Code enforcement officer, can I ask a question? Had when he went downstairs and paid his BTR, if they said, "Oh, you need to pay your certificate of use too," and had he paid that, would we be sitting here today?
No, sir. And last year, he had both of them, so he should know that you have to have both.
And
So,
is it your testimony to me that you went downstairs and paid the BTR in person?
Yes.
And is it your testimony that you asked, is there anything else I need to do?
Yes.
The only issue for me on this is cost. And that's why I was curious because through nobody's fault, his story is credible to me. It happens in city halls all the time. And again, nobody's fault because he's asking about a BTR and they're looking at a BTR. Oh yeah, this is paid your BTR. They're not thinking certificate of use. But I suspect how much was that certificate of occupancy, or how much certificate of use?
well, with penalties, I know the penalty is 100, so it's probably roughly around 150 or
But my
so.
point is, had somebody told him, if he's standing at the window, had somebody told him, "Oh, you also owe $150," he probably would have paid it.
possible, yes.
Would you have?
Yeah, of course.
So I'm inclined on this one to find the violation exists, order him to cure, but to not impose costs, because there was, I think, an opportunity. And again, it's nobody's fault, but I think here's my honest thinking. He did everything I would have asked him to do, and I think that's why I asked the question. He did everything you would have asked him to do too, and I think there was just one piece of information that got missed. And in this case, it leads me to say, I think in the interest of fairness, that I should not impose costs.
Yeah, the only thing I have to say is I did call him and leave several messages. Catherine called him and left messages, but I understand
He's a
also
truck
where you're
driver.
coming.
Yeah.
Yes, I understand.
That it was when he said that it kind of that my brain shifted a little bit, because they live a different life than those of us who work a 9 to 5 in an office building. So with that, then, unless you have anything else you'd like me to hear, that is going to be my order. You are in violation for that certificate of use. You need to get that. You'll probably do it as soon as you possibly can. I'm sure you will. I'm going to give you until September 28th to do it. On this case, I am not going to impose costs, though, so I am going to deny the request for costs. So all you got to do is bring it into compliance. You don't have to worry about any fines or penalties.
Yeah, I'll do it tomorrow morning, but before I leave here, I just want to make sure, what is it that I really need to go and pay tomorrow?
The certificate of use.
Certificate of use, that's it?
Yes, just ask for planning and zoning.
Uh-huh.
Tell them that you need to renew your certificate of use.
Okay,
Just remember, both of them are due again by September 30th.
okay.
So you might just go ahead and say, can I go ahead and pay for next year when you
Yeah.
pay? And your BTR too, just say, hey, look, I've got to do this, and I know BTR and certificate of use for next year is coming up. Can I go ahead and pay that also right now? Save yourself a trip.
Yeah, thank you so much.
Yes, sir.
Thank you.
Case number 2023-727, Doris Risso, owner, location of violation, 1019 Georgia Avenue, St. Cloud, Florida.
Good afternoon. April Bennett, Community Compliance Officer for the City of St. Cloud. I'm presenting this case for the property located at 1019 Georgia Avenue. At this time, I would like to enter into evidence the following items. Copy of the notice of violation sent by certified mail, posted on the property and City Hall. Copy of the statement of violation and notice of hearing sent by certified mail, posted on the property and City Hall. Copy of the PowerPoint presentation. Affidavit of postings. Evidence of mailings, the code section in violation of, a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $341.80. He is here and has been provided copies. I wanted to provide a little history on this property. This property is owned by Doris Rizzo, who does not reside at this location. Doris lives with her daughter in Tennessee. The occupants of the home are the owner's grandchildren, great-grandchildren, and various roommates.
Who's present today?
I'm,
Okay, so it's not Ms. Rizzo who's present. That's. Okay. Sorry, you can proceed. I wanted to get that clarified for my own knowledge.
okay. This property has been written up multiple times and was brought to the magistrate and found guilty twice in 2022 for no active permit, abandoned vehicles, keeping of pigs, exterior property sanitation. On April 20th, after receiving a complaint from a neighboring property in reference to water being stolen from her property, an inspection was completed with the assistance of the St. Cloud Police Department. I was able to verify that the water at 1019 Georgia Avenue had been shut off for approximately 2 months, so I red tagged the home for no water and no sewer. While red tagging the property, several other violations were observed. There were numerous vehicles without current registration tags. There were electrical hazards, accumulation of rubbish and debris, a pig being kept, washing machine that was not properly hooked up, so the gray water was being discharged on the ground, a roof in disrepair, and 25 photos were taken.
What am I looking at in this one?
That was just the backyard. I was getting pictures of the accumulation that was there. It's hard to see. It's in the back corner there of the photo, so it didn't come out very clear, but it's just the overall accumulation in
So
the
just
yard.
more accumulation.
Yes, sir.
You'll get your chance. Don't worry. What is? No, sir. Two things. One, I need to have you at the podium, and two, I need to swear you in before you present to me. So we'll just wait. Trust me, I'll give you plenty of time to explain anything you want to explain. I'm just trying to, as I look at these, I want to know what I'm looking at. What am I
It
looking at?
was an
here?
electrical box that was connected to the tree that was operating that light.
Okay.
After the inspection was completed, Supervisor Howells contacted Suzanne Haney, which is the owner's daughter that she's living with, to advise the situation at the property and that the home was red tagged. Susanna called the water company and made a payment arrangement, so the water was restored that evening and the red tag was removed. On May 15th, a reinspection was performed and I was able to verify that the pig was removed. However, the rest of the violations had not been addressed. The tenant advised that he was working on getting the property cleaned up. He was told to contact us as soon as the violations were corrected so we can complete a reinspection. 11 photos were taken.
What am I looking at here?
No tag on the truck.
Oh, okay, thank you.
That is in the front of the house. The area right there at the edge of the roof is rotted wood, so the eaves it's exposed to elements. On May 30th, I sent out a statement of violation and notice of hearing by certified mail, posted the property and City Hall, did an affidavit of posting, and took 2 photos. On June 14th, I received a call from a neighboring property in reference to open ground burning at this location. Supervisor Howes and I went to the property and made contact with the tenant. We were able to verify he was burning, and he was told to extinguish the fire. I was also able to verify that the plumbing violation was corrected. However, the other violations were not corrected. 9 photos were taken. On July 6th, while I was in the area on patrol, I observed a trailer in the right-of-way without a current registration tag. 1 photo was taken. On August 21st, I received a complaint from a neighboring property in reference to an unregistered trailer belonging to the tenant at 1019 Georgia being parked on her property. An inspection was completed. I observed the trailer on her property and 2 trucks parked in the right-of-way. There was a truck that was missing a wheel, and the other truck did not have a current registration tag. So they were both red tagged with 24 hours to remove them from the right-of-way. The owner of the neighboring property had the trailer towed from her property. 8 photos were taken. On August 22nd, an inspection was completed to follow up on the red tags. The missing wheel was replaced on the truck, however, it was not operable due to a missing part. Supervisor Howells
When you
allowed...
say a missing part, what do you mean?
He said he was waiting on a part to come in for, I think, his rear drive shaft, so he
So
had...
not something you observed, something that that the tenant told you?
Correct. Correct. Supervisor Howells allowed additional time to get it repaired. The other truck was still in the right-of-way without a current registration tag. The tenant was told that the truck was going to get towed, and the St. Cloud Police Department was contacted to assist us with having the truck towed. Once the police arrived, the tenant agreed to move the truck from the right-of-way and back it into the yard. 4 photos were taken. On August 23rd, I was able to verify that the truck was repaired and operable. I still did not have proof of registration for the other truck that was backed into the yard. On August 25th, I was in the area on patrol, and I observed a car parked in the right-of-way without a current registration tag. 4 photos were taken. On August 29th, I was in the area on patrol, and I observed that the car was moved from the right-of-way but was backed into the driveway with a piece of furniture placed at the rear of the car to block the tag area. 2 photos were taken. On September 1st, I re-noticed with an updated statement of violation and notice of hearing sent by certified mail, posted the property in City Hall, and did an affidavit of posting and took 4 photos. On September 8th, an inspection was completed and the violations were not corrected. The car and the truck were still at the location. I've not received proof of registrations. The other violations have not been cured. 2 photos were taken. It is the city's recommendation that the respondent be found in violation of allowing an accumulation of solid waste, exterior property to be kept in an unsanitary condition, electrical hazards, unsanitary plumbing discharge, rotted wood on the eaves, and repeat violations of allowing abandoned vehicles at this location and not corrected by the time specified. The city would recommend that the respondent be given until September 28th to correct the violations, or a fine in the amount of $100 a day be assessed until compliance is met. On the repeat violation of allowing abandoned vehicles, the city would recommend $500 a day from April 20th, which was the first day the violation was observed. The city would also request the cost incurred in bringing this case before the magistrate in the amount of $341.80 to be paid within 7 days of the written order by the special magistrate. And that concludes my presentation.
Okay, can you talk to me about the unsanitary plumbing discharge? Where's that?
They had a wash machine out back that they were discharging on the ground.
Did you have a picture? That's okay. All right, so he may be able to answer for me. I'll let you have to look for a minute. If I need to, I'll get you to find it, but it's okay. You don't have to find it. Because
Okay.
Let's get the respondent you can approach. Did you have any questions you wanted to ask the code enforcement officer before I turn it over to you to give me your testimony?
No, ma'am. No, sir.
That's okay. If you'll raise your right hand, let me get you sworn in. Do you swear from the testimony you give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, and first off, tell me about the
They did have a washer out there, and it was hooked up out back, and the discharge was running on the ground.
okay. And your name?
Kevin Ahern. I'm
And
a
your
friend of
relationship to the property?
Friend of the family.
Friends of the family?
Yes, sir.
So you're here for Miss Rizzo?
Yes, sir.
And she knows you're here on her
Yes,
behalf?
sir.
Okay. You are not the tenant?
No.
Do you have, are you familiar with, do you know the tenant, and have you had
Yeah,
communications?
I do know the tenants. I mean, I'm not like super familiar with
But
them.
you've had conversations with them?
Yes, yes, of course.
And so this is their stuff, I assume, am I?
Yes, and the vehicles, so what he buys vehicles and fixes them up and sells them. So the vehicles that they had, okay, like the one without a tire, it didn't have a tire on it. He was literally out getting the parts for it when they tagged it. When he came back, he put the tire back on it, moved it. So they think he's just working on it's not abandoned vehicles. He buys them, fixes them, and sells them. What's wrong with that? Okay, maybe he's running a business out of his house that he should have a business license for that, maybe. I don't know. That part I don't know.
Well, let me
Like I
share
said,
with
they're not
you-
abandoned vehicles.
But they are disabled or unregistered. And let me share with you some cases that I've been involved with over the years, so that you can share with him, frankly.
Yes, sir.
Because I hear you making the argument that he'd probably be making to me if he were standing here, where it has been actual mechanic shops who, and actually as mechanic shops seem to phase out of our culture, the ones that still exist get busier and busier.
Right.
And they put more and more cars. Most, at least in the metro area, are in areas where cities have adopted codes that provide the same thing here that we're doing on the residential lot. You can't have unregistered disabled vehicles exposed to view. So often, these mechanic shops, they're in a jurisdiction where they even have to move it into a garage. It has to be in a bay with a closed door. You cannot have those overnight out in the parking lot that everybody drives by and sees, because it's unsightly, it's problematic. And so I appreciate that he's working on these cars. Whether or not he needs BTR, that's not before me today, so I'm not going to rule on that.
Right.
But even though he's doing a business, he may have to modify how he does that business, because he cannot have disabled, unregistered vehicles on this property. If they don't have a tag, he's going to wind up here. If they've got a flat tire, he's going to wind up here. If the engine's broken, and even if he's actively working on it, he's going to wind up here. He's going to have to figure out a way of storing those either off-site, and if there's not somewhere here where he can enclose them on-site, he's going to have a problem.
So my next question to you is, so with those vehicles, if they were in the backyard, are you not allowed to own a vehicle and not have it registered? Can you not be working on a project vehicle? Is it illegal to have a vehicle in your backyard? I'm asking because I don't know either. I mean,
I'm not the right person to ask, because I'm the judge,
right? Yes,
not
sir.
the code enforcement officer, but
Yes,
that's
sir.
probably a conversation worth having with
Okay.
code enforcement. How can he do this? Not right now, when we're done with the hearings, but how can he do what he wants to do? And if there's a way, I'm sure the city will
I'll
work
talk
with
to him
him.
about it. Yes,
But, but if there's a garage, he can close them in. And so project vehicles, I'm glad you raised that one, because those come up in code enforcement, not frequently, but from time to time they
How
do.
about we just
But it's a good example of somebody. And so the answer with project vehicles in most jurisdictions is, by all means, you're allowed to have a project vehicle, but you need to have it in a garage.
Okay.
And when you're not working on it, when you're not in that garage with it, you need to have that door closed, so that
Understandable.
everybody else in the neighborhood doesn't have to look
Okay,
at it.
got you. Here's what it boils down to. The eaves will be fixed. Anything that you guys want taken care of will get taken care of. Can I
How much
address them?
time do you need?
They said till the end of September. I feel that's fair.
Okay.
I feel that's fair.
Okay.
Give us till October 1st.
So I saw September 28th, and I was looking at the pictures.
Is fine.
That's quite
I'm
a
not
bit of
looking
work.
at a calendar. I mean,
So
that's-
I'm tempted to give a little bit more than September 28th. I think October 1st. That's 3 more days than they've asked for.
Okay.
I'm
Until
thinking
October
middle of
15th.
October.
Yes, sir.
Is there a reason that I should be aware of from code enforcement standpoint why this shouldn't be given a little bit more time, just to make sure that they have enough time to get done what they need to get done and done right?
Yeah, and if that's what you see fit, then I will be okay with that. I just want to make sure that you understand this case was started back in March. He's had ample time to know, he knew what he needed to do back in March, but we had to delay this case because of the IPMC adoption. So there's been plenty of time to bring it into compliance. This isn't new.
I understand, and I do, but I also, just like you have to give a reasonable time to cure, when I enter an order, I do too, and that's September 20th. There's just a lot that has to be done. If
understood.
it were half of what has to be done, I'd say, yeah, no problem. He said he could do it, and I hope you will. I hope you get it done as fast as you can get it done, but I am going to give it October 15th as a compliance date.
Okay,
For that, and April Day, because I want to talk about the fines, and I wrote it. So at $500 a day until April 20th, we're at $73,500 for the fines. And honestly, if the tenant were the owner, I might impose. I might be willing to impose that. But here I'm dealing with an absentee landlord, and who's even present before me through a friend of the family. And I want to convey the message, and sir, I want you to convey the message to Ms. Rizzo. She needs to get after her tenant because he's costing her money. And if I see it again, now that I've said this to you and I trust you're going to communicate it to her, I'm not going to be as lenient if I see disabled vehicle case on this property again, because I'm telling you to tell her, make sure it doesn't happen again. Because it could have been $73,500 and continuing to run. I'm going to ask. And I'm gonna do this. I'm gonna ask what the city thinks of a carrot and stick approach to if those vehicles are removed or properly, are no longer in violation. They don't have to be gone. If they work or if they're tagged, they can stay. But those vehicles have to be in compliance by the original September 28th date. If they are brought into compliance of that date, that $73,500 that it could be will be reduced to $1,000 flat fee. Done. Does that seem reasonable to from the respondent's representative?
So, say that again. So
She would, as long as those vehicles are made compliant, or gone is compliant, then that $73,500 that it could be will be reduced to $1,000.
yes, sir. I agree with that.
And city, does that seem reasonable from your standpoint?
Even on a repeat, because this is the second
It's a repeat, the management understands that, but, and this is a multiple repeat, as a matter of fact, but we'll entrust that this won't
And I'm going to
occur
put that
again.
same language that I asked to be conveyed in the order, that if it happens again, I will not, if it comes before me again, I will not be as lenient as I've been on this one. And what's motivating that leniency is because they're not her vehicles.
No, I understand.
She's absentee.
understand.
I'm guessing she's older, sir?
Yes.
So, so you're not punishing the tenant. You're not punishing the person who's doing it by imposing $73,000 against Ms. Rizzo.
Yeah, the understanding is that the vehicle compliance component by September 28th of this year, and as long as that is achieved, just a $1,000 flat fine on that repeat. And the other compliance dates would be October 15th of this year.
You do realize it's for grandson though, right?
The tenant is the grandson?
Yes.
No. That makes my math a little bit harder in my head, but I still have a hard time. And honestly, if it happens again, what I'd like to see happen is the tenant be named also, and some jurisdiction over the tenant be given to me, because as you heard me say in that first case, I can enter an award against tenant. There's less teeth in it, but it's just, that's a lot of money for what I'm sure is an older woman who's not paying attention to that property, and that's on her, and I want that conveyed to her. She needs to be paying attention to what's going on her property. And it's already cost her some, and it could have cost her a lot more, and if it happens again, it's gonna cost her a lot more.
Trust me, I will let her know.
And I won't say anymore. Okay. Anything else, any of the parties? And
Just so we understand, the other
Costs are being
violations-
awarded.
Costs awarded, and that's 341.80, and the other violations comply by the 15th of October of this year, or,
the city's order, $100 per day.
thank you, sir.
How long the cost? How many days?
There were permits already
Yeah,
pulled
thank you.
You're
for
welcome.
the work, and he's allowed those to be expired, so you're gonna need to figure that out with the building department, because there does have to be active permits for the work that you're wanting to
To
get
fix
completed.
the soffit? I gotta have a permit to fix the soffit?
The woodwork and stuff that needs to be completed. He's already pulled a permit for that work,
Okay.
but then he never
So I need to
let
pull a
it
permit.
expire.
Now, is that gonna mess my time up? Am I gonna be able to do that in your?
By October 15th, yes.
Okay.
Yeah, if it were September 28th, you'd be a little bit more crunched, but yeah, you should have no problem
So
getting
if I
that
go
done by
down
October
tomorrow and try to
15th.
pull a permit, I should be able to get that done before the
Yeah.
15th?
Doris has to be the one to sign off on pulling the permit, so yes.
But she can do that. You can do that remote. I mean, that can be worked out, but yeah, it won't be able to be issued on that spot. You're gonna get it signed by her.
Not a problem.
But yes, welcome to Florida.
As
That's,
long as they don't try to say, hey, it's gonna take too long.
if you're familiar with permitting from other states, Florida's a little bit tighter on our building code because of the wind-blown debris. That's why things like soffits, that in some states, yeah, you can repair your own soffit. In Florida, we're worried about a soffit coming loose and flying through and, severing somebody's arteries.
Okay.
The clerk reminded me on the cost. I am entering the award of cost of $341.80. Is there any hardship that would prevent that from being paid within 7 days from the date of my order, which will probably be 7 days from either Friday or Monday? That's the date that I'll probably get around to
So
signing
that'd
this.
be 300.
340, about a little less than $350 due within 7 days. Is there a hardship with that?
No, sir.
Okay. Then that will be due within 7 days of the date of my written order.
And that's just basically for having to come here, their cost.
The cost the city has incurred in prosecuting the action, yes, sir. And again, there will be a written order that will come out, and if you, I would like to, you do not have to give me your address, and you can write it down and hand it to the clerk if you'd like, rather than announcing it to the room. But it will become a public record if you give it to me. But I would like to send you the order that I'm going to prepare in addition to sending it to Ms. Rizzo, so that you can help her make sure that it's getting communicated to
I
her.
appreciate that. I'll give you my name and address. My name's Kevin James Ahern. I reside at 3030 South Atlantic Avenue, apartment number 102, Cocoa Beach, Florida, 32931.
So I have Kevin Ahern, 3030
South Atlantic
South
Avenue.
Atlantic,
Avenue. What number?
Suite 102, or apartment 102?
102?
And that's Cocoa, not Cocoa Beach, right?
No, Cocoa Beach.
Oh, Cocoa Beach.
Yeah, if you were to say that to a real local, they'd be mad.
I know. Well, I just wrote down Cocoa. I didn't write down Cocoa Beach. I am aware that they are two distinctly different places, and the zip code was.
32931.
Thank you. I appreciate that.
No problem, sir.
And so you'll get the same copy. You'll get a copy of the same order that goes to Miss Rizzo.
Okay, excellent. Thank you.
Anything else from anybody? Thank you.
Thank you. Appreciate your time.
Case number 2023-1254, Williams Marte Jr., owner, Maida Giuliani, owner, location of violation, 1001 Carolina Avenue, St. Cloud, Florida.
Good afternoon, Pam Neal, City of St. Cloud Code Compliance Officer. I am presenting this case for the property located at 1001 Carolina Avenue. At this time, I would like to enter into evidence the following items: copy of the notice violation sent to the owner, copy of the notice violation sent by certified mail to the owner, copy of the statement of violation notice of hearing sent by certified mail to the owner, copy of the PowerPoint presentation, evidence of mailings, copy of the deed to the property, copy of the code sections in violation, copy of the costs incurred if the special magistrate finds the respondent in violation in the amount of $275.90. The respondent is here, and he has been provided a copy. On June 26, 2023, I received a complaint about a new fence installed at this location. On June 26th, I went to verify, and a new fence had been installed without a permit. I noticed a small trailer with no tag. On June 27th, a notice violation was sent to the owner, which I could have cited for a repeat violation on the fence, but I decided against that due to the fence was a replacement, and then a permit had been obtained years ago. So I decided against doing it as a repeat. On July 10th, a reinspection was performed, and there was still no tag on the trailer, and no permit was obtained for the new fence. On July 11th, a notice violation was sent by certified mail to the owner, and I took 2 photos. On July 12th, I noticed that a permit had been applied for. On July 26th, a reinspection was performed, and the trailer was backed in, and I couldn't verify if there was a tag on the trailer. I checked the fence, and the fence permit had been approved on July 17th. I called the owner and told her the permit was approved and it needed to be obtained, and the trailer needed to be turned around so I could verify if it had a tag, and I would check on the permit and perform an inspection on July 31st. I took 1 photo. On July 31st, a reinspection was performed, and the trailer was still backed in, so I could not verify that it had a tag, and the permit was not obtained. I took 1 photo. On August 1st, the statement of violation and notice of hearing was sent by certified mail to the owner. On August 11th, a reinspection was performed, and the trailer was still backed in, so I could not verify, and the permit was not obtained. On August 21st, a reinspection was performed, and the trailer was out, and I could see that there was still no tag attached, and the permit had been obtained on August 16th. I took one photo. On August 29th, the reinspection was performed, and there was still no tag on the trailer. I took one photo. On September 5th, a reinspection was performed, and the property is now in compliance. The trailer had been moved. It is the city's recommendation that the respondent be found in violation of allowing a fence to be constructed without first obtaining a permit and an abandoned vehicle at this location. The city would like to also recover the costs incurred in bringing this case before the special magistrate in the amount of $275.90 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
Okay, thank you. And respondent? This is yours, right? Okay, and before you, as you come up, when you get up here, I'm going to swear you in. You'll raise your right hand for me, both of you. Do you swear from the testimony you give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Before you start, were there any questions of the code enforcement officer you wanted to ask before we get to your testimony?
No.
Okay, then what would you like me to hear?
Okay, before the fence had been blown down a couple of times due to the hurricanes that we've had in prior months, and we had tried to get a couple of companies to come out to try to fix or put the fence up, but they wanted to charge anywhere between $8,000 and $10,000. It was ludicrous. So I looked inside the permitting, and I also, not looking at permitting, I looked at the laws and bylaws of either replacing or fixing a fence. And I was basically fixing the fence. The post just needed, all I did was replace the slats inside of it. That was it.
When you say you looked, where did you look?
On St. Cloud codes with the fences.
I thought that's what you were going to tell me, and let me tell you, and it's not a mistake because you would not have known. Florida Building Code is what governs that. It's the state code, and so that's what's triggering it. And you heard me say Florida has very strict rules, and it's because of the wind blown. So things that you might not have to have a permit for elsewhere, but whether or not you have to have a building permit, that's Florida Building Code. St. Cloud Code will not tell you whether you have to have a building permit.
Got it, and that's where I looked. So I commend me and my best friend, and even our neighbors. They said, all right, come on, we'll help you out, Will, because it was going into and we also have dogs that I wanted to keep in. Second, no complaint was made against us. We are wonderful with our neighbors. Literally,
you seem very pleasant.
We know all our neighbors. We bring dinner to our neighbors. Neighbors come to our house all the time. And with the trailer, I was trying to sell that trailer. I was trying to sell that trailer twice. No one came by. No one looked at it. Hence why I left it there. And also in the pictures, you can see the wood from the old fence was on the trailer. We didn't want to put it on the ground on the grass or near the sidewalk. But we have kids. There's a school bus drop that drops there. And these kids go onto people's properties, and that's all I needed for a kid to step on a nail from an old fence. So I put it on the trailer in the corner. Other than that, I do have a tag for the same day that I went on July 17th. That's the second time I went up to downstairs to permitting. There was an issue. They told me that the fence was 5 feet away from the street. And I tried to tell them, no, it's 25 feet away from the street. So that took another week and a half to absolve until the manager came in and got a Google shot of it. And he's like, where's the fence? And I'm like, here and here. He's like, okay, now I see the mishap. So I went back there. Again, I went downstairs 3 times to make sure. When I found that our permit was approved, I paid for it, got it. I have the permit on our door, and I have the permit on our fence and on the other side of the fence. But other than that, there is a tag for that trailer. It was got on the 17th, the same day I went to go get the updated permitting as well, too.
The 17th of
July.
But that's not the same day that you found in compliance, right?
Well, I got a picture on the 26th of the trailer that doesn't have a tag.
Which only gives you, 20 days? If that, I didn't know how long I needed to get it, because I thought I had it, and I didn't have it on the trailer.
Oh, so
I went
you
to go
had
get
it in hand, it had not been affixed to the
Yeah,
trailer yet.
Exactly. And I can't put the trailer or anything in the backyard because
So-
of I'm sorry, go ahead.
No, I was making sure I was giving due credit to your argument. So here's where I am. I'm still open to hearing more if there's more to be presented to me, but I am starting to move to a resolution of this case. The city agrees, you're in compliance. They're not seeking any fines. The only dollars at issue now are those administrative costs of prosecution, which the city has asked $275.90. You were explaining to me when things came into compliance. Tag paid for, not on the vehicle. I understand why it's cited and you're finding it not in compliance. But on June 27th, you were given 7 days. So even taking your date, it came into compliance after the compliance date.
I mean, I didn't have the money to get it, and it was just it's only a 6x8 trailer. It's a small little trailer.
I understand.
I can understand if it was a broken down car or it looked
But
bad,
that's why I
fine.
say this is not a fine. This is, if the city doesn't get compliance within the date set in the notice of violation, this gets put onto the hearing and they have to do work that the city starts incurring costs. And that's why I say I'm open to hearing more, but in 99% of these cases, I'm going to award the cost because it's not any other St. Cloud taxpayer's responsibility that you're standing in front of me today.
I know I understand a taxpayer, and I'm also a small business owner in this place as a retired vet as well, too. But at times, we literally just spent $80,000 to get the roof in compliance and a whole bunch of things. But money was tight at the time. I didn't have the money. The minute I had the money, I made sure both this and the trailer was done. 7 days, I'm sorry, but it sometimes can't do it.
No, this is not a penalty. This is simply to make.
But it is going to be a penalty because it's $275.
But it's not a
incurred.
penalty. A penalty is punishment. This is, the respondent pays for the cost of the proceeding that was because of their violation. You don't dispute that there was a violation. You don't dispute that it wasn't brought into compliance within the time that you were originally allowed.
So I overlapped it by 7 days for a trailer.
Yes.
And that incurred me, so a $60 cost me $275 to come up here when she could have just went right across the hall where the DMV's at and it's public record to say this was in compliance, just like she did.
Not your job?
But wait, if it's not.
No,
hold on a second, if
it's not. No, we don't need the crosswalk. I'm going to go ahead and order. Do you need more than 7 days to pay the $275?
Yes, sir.
Yes, sir.
How much do you,
Like I
how
said,
much do
I
you need?
just spent
How much time do you need?
$80,000.
Sure. How much time do you need?
At least 2 to 3 months. I
To
mean,
pay $275, you need 3 months.
Sir, we've just invested $80,000 on an air.
I'll give you 30 days.
On a roof. How many?
30.
I asked 45.
30. I've ruled.
Fine.
Yes.
Case number 2023-1056, Barbie Palmer, owner, location of violation 1321 12th Street, St. Cloud, Florida, reduction of lien. We're skipping because she's here.
Because we have response present, we're skipping, we're getting the people who are here
Sorry.
out. So, sorry,
problem.
yeah, she was asking me and we didn't tell you what was going on.
I'm up, no problem. Okay, so what we have here, I know Ms. Palmer is here. This is a resolution of a case that was heard back earlier this year. Date of compliance on the violation was June of this year. Total fines accrued of $12,500, administrative costs of $214.60, 214.6. Total fine of $12,714.60. City manager has recommended a settlement of $2,714.60 to be paid within 30 days of the magistrate's order, if accepted by Ms. Palmer. Ms. Palmer met with me before today's hearing. She wasn't sure whether
And
she
she's
was-
signed off now.
Okay, wasn't
On the
sure,
version
so-
in front of me, and she has signed.
Okay, so we're presenting it to you for approval.
No, it's in my packet.
Yeah, Did you
No.
want to speak?
I don't have the sign, but I have the
yeah.
unsigned. I just need the data off of it, so it's fine.
Is it okay? Yeah? Okay. Yeah, she just,
Good.
yeah, we're
Okay.
in agreement. So-
Then I will approve it upon the terms agreed to by city manager and
Ms. Palmer,
Ms. Palmer.
okay. All set. Yeah. He accepted it.
And I appreciate that, because it's better than the original amount, which is just unattainable.
Yes.
I wasn't here for the first meeting on this, because I was out of town. I wasn't even aware that there was a problem until I came back into town. Came back into town June 27th. Also found a letter in my mailbox about the violation. I fixed it within 2 days and called code enforcement to let them know that it was fixed. I was not aware that there was a meeting on this, June 21st. I wasn't in town and I wasn't aware of it. So I just wish I'd been given a little bit of time to cure this. It shouldn't have been a problem to start with, but once I was aware there was a problem, I fixed it immediately. I signed this because I didn't really know what else I could do. So I don't know what to tell you, but I just wish that I had had a little bit of time to cure it. And if I hadn't been out of town, this wouldn't have been a problem to start with. So I apologize for that.
No apology necessary. Thank you for getting it into compliance.
Yeah. Can I have a little bit more time to come up with that money? I know I signed it for 30 days because I just needed another month.
As I explained to Ms. Palmer, I'm not authorized. The
Yeah.
city manager has agreed to what she's agreed to, and Ms. Palmer had the right to agree
And that's
or
what
not.
was presented, the 30 days is what was presented to me, and that's what I've approved.
All right, I'll do what I can. All right, thank you.
Yes, ma'am. Back to Luther.
Case number 2023-1334, Cipriano Rene Borelli and Ida Luz Borelli, owner, Nelsie Adeline Borelli and Samuel Cruz, owner, location of violation, 500 Pennsylvania Avenue, St. Cloud, Florida.
Good afternoon, Pam Neal, Code and Compliance Officer. I am presenting this case for the property located at 500 Pennsylvania Avenue. This time I would like to enter into evidence the following items: copy of the notice of violation, copy of the notice of violation sent by certified mail, copy of the statement of violation, notice of hearing sent by certified mail, copy of the PowerPoint presentation, the affidavits of postings, evidence of mailings, copy of the deed to the property, copy of the code sections in violation, copy of the costs incurred if the special magistrate finds a respondent in violation in the amount of $304.80, and the respondent is not here today. On July 6, 2023, while on routine patrol, I noticed the grass and weeds were high and the water in the pool at this location was black. I took 5 photos. On July 7th, the notice of violation was sent to the owner. On July 20th, a reinspection was performed and the grass and weeds were not mowed and the pool water was still black. I took 4 photos. On July 26th, the reinspection was performed. The grass and weeds were not mowed. The pool water was still black. I took 3 more photos. On July 27th, the notice violation was sent by certified mail to the owner and posted on the property in City Hall. Affidavit of posting was completed, and I took 1 photo. On August 7th, the reinspection was performed, and the grass and weeds were not mowed, and the pool water was still black. I took 4 photos. On August 10th, the statement of violation notice of hearing was sent by certified mail to the owner and posted on the property and City Hall. An affidavit of posting was completed, and I took 4 photos. On August 28th, the reinspection was performed. The grass and weeds had been mowed, but the pool water was still black. I took 1 photo. On September 5th, a reinspection was performed, and the property is now in compliance, and I took 1 photo.
Ooh, that's a much better looking pool.
Yeah. It is the city's recommendation that the respondent be found in violation of allowing the grass and weeds to be over the height of 8 inches and the pool water to be unmaintained and not in a clean and sanitary condition at this location. The city would like to also recover the costs incurred in bringing this case before the magistrate in the amount of $304.80 to be paid within 7 days of the written order of the magistrate as well. And that concludes my presentation.
I'll enter the order as requested by the city.
Thank you.
And I've been advised by the clerk that we got to get out of here by 6, so luckily we're down to the last one, without the exception of the reductions.
Case number 2023-1565, Brian C. Luther, owner, repeat violation, location of violation 4724 Lake Trudy Drive, St. Cloud, Florida.
Good afternoon, April Bennett, Community Compliance Officer for the City of St. Cloud. I'm presenting this case for the property located at 4724 Lake Trudy Drive. At this time, I'd like to enter into evidence the following items: copy of the statement of violation and notice of hearing sent by certified mail posted on the property and City Hall, copy of the PowerPoint presentation, affidavit of posting, evidence of mailing, code section in violation of, and a copy of the deed to the property, and a copy of the cost incurred if the magistrate finds the respondent in violation in the amount of $245.60. They are not here.
Because the clerk has given me a time frame, I'm going to let you give me the Cliff's Notes version.
Cliff Notes version is this is a repeat violation. These are the photos that were taken.
Tell me about your notice of violation. When did you send it? What did you notify them of?
On August 23rd is when we originally saw the violation. Research to write it up, I noticed that they were repeat violations that he was found guilty of October of 22. The statement of hearing notice of violation was sent on August 24th.
Did you provide a notice for today's hearing?
I did. That was provided, well, they were only provided the statement of hearing notice of violation because it was repeat violation, so they were coming straight back to the magistrate.
They resolved the issues with the vehicles. No need for any order from me on those.
The vehicles, no, there's still a car in the driveway that has a flat tire. That car there's a trailer that's on the property that's dug in the ground. Two of the vehicles.
Are you asking me to enter an order on that? It's not in the request.
The
that's why
abandoned
I'm
vehicles
asking.
in the high grass and weeds, is it not on?
Oh, I see. Abandoned vehicles. No, I missed it. Okay.
Okay.
And they're both repeat. Both of those are repeat?
Yes, sir.
Okay. Did you send a notice of today's hearing to the respondent?
Yes.
When did you send that?
That was sent out on August 24th. I sent the statement of hearing notice of violation by certified mail and posted the property.
I'm prepared to rule. Is there anything you'd like me to hear before I do so?
The only thing that we're asking is $500 a day from August 23rd, which is the date that the violation was first observed.
I will enter that order, find the respondent is in repeat violation for high grass and weeds and abandoned vehicles. Enter the requested award of $500 per day dating back to August 23rd, which amounts to $11,000 as of today. That amount continues to run at the rate of $500 per day until compliance is met. Also order the respondent to pay the administrative costs incurred by the city in the amount of $245.60, which amount will be due within 7 days from the date of my written order.
Thank you.
Reduction of liens under 50,000, case number 2018-2051, Oscar J. Ellenis, owner, location of violation 334 Carolina Avenue, St. Cloud, Florida.
And Clyde, couldn't do the second one as
So
well?
2019-711, also Oscar J. Ellenis, location
Correct.
of violation 334 Carolina Avenue, same address,
Yes.
two different cases.
Exactly, yes, sir. So proposals for settlement signed by the respondent, or I guess Ms. Encarnacion. In 2018-2051, the proposed settlement agreed to by city manager is $1,450 in so long as it is paid within 6 months of your order. The other case, 2019-711, is a recommended settlement of $2,637.48 so far as if paid within 6 months of your order.
Approved and upon the terms agreed to by the city manager and the respondent.
Thank you very much.
Case number 2023-616, Brady Bennett, owner, location of violation 2010 Pine Street.
Your Honor, on this one, I don't have a signed agreement. If we don't have one, we can.
Clerk has one.
You have one? Okay, great. So this is, a compliance date was July of this year. The accrued fine of $3,900, administrative cost $265.70, total owed $4,165.70. Settlement recommendation from city manager agreed to by respondent $1,265.70 if paid within 30 days.
Approved upon the terms agreed to by the parties.
Thank you, sir.
New business,
There you go.
New business none. Next scheduled meeting, October 18, 2023.
Anything else from code enforcement? Nope, good.
Appreciate your
Thank
time
you,
today.
everybody.
Appreciate your time.
You're adjourned.
I have your books, Catherine.